Bless your lordship. Lordship, I'd like to mention orders item 44 and 45. Last occasion,
Yes.
your lordship was blessed to direct me,
44, 45 is hearing matters.
lordship.
Yes.
Now that I have information that the government could furnish the details only on a Monday. So
You
Let
need
this
time to
matter-
file your reply.
let this
44.
matter will come up on Tuesday,
44, 45.
44, 45.
Yes.
Has no objection, Lordship.
Your affidavit would be ready by Tuesday.
No, I was directed to bring instructions.
All right.
That's
Item
what-
44, 45 at the request of learned senior government advocate. Matter stands deferred. Sloppy submits that he has not completed his instructions and therefore submits that the matter be listed again on Tuesday, which is 19th. 19th,
Yes, my lord.
no objection from the council for petitioner. Council for accountant general. Lordship, you are for?
The AG.
AG, accountant general, is
Accountant.
also present. Yes.
Bless you. May I please, Lordship? Lordship, I beg to mention item number 36 and 37.
Item number
36 and 30. This is a part of matter, Lordship.
36, 37.
Yes, Lordship, if this matter be taken up at 2 after the break, I have some
All right, second up,
second of Lordship.
36, 37 at 2 PM. Huh? You don't have to write it. 36, 30, yes.
I believe, so, Lordship. Lordship, I would like to mention item number 30. Lord,
30.
yes, Lordship. I pray that if the matter can be listed next week on Tuesday,
Item 30. the
Yes, Lord.
request of
petitioner for the petitioners.
counsel for the petitioner. Matter stands deferred to be listed next week. Prayer is not objected to by the government advocate. Yes.
Much obliged.
I pledge.
May I please, Lordship? Lordship, I beg to mention item number 46 and 47. That's hearing item number 46 and 47.
Yes.
Lordship, today there are some personal difficulties, so I pray the matter may be released after a week. Lordship,
46, 47. You are for the petitioner.
petitioner, Lordship.
You're Mr.
I, Jamir.
Sir I Jamir, learned counsel, hearing for the petitioner. Submits that the matters be deferred for the week and be listed next week. Prayer is not objected to by the.
I've taken consent, Lordship.
Okay, he submits that consent of the learned CGC has also been obtained. Accordingly, matters be listed next week.
Lordship, obliged.
May I please, your lordship? I beg to mention item number 38, 39, and 40. Your lordship, kindly grant us 2 weeks' time to file our amended petition.
You want to file?
Amended petition, your lordship.
amended petition, 38, 39, 40.
Yes, your lordship.
Counsel for the petitioner prays for further time to file the consolidated amended petition.
Much obliged.
Matter be listed after a week.
Much obliged.
Your Honor, I beg to mention item number 35, which is in orders. The notice has been completed. I have to file my affidavit in opposition. It's almost ready.
You're for the respondent.
Yes, my lord.
Item 35, your Mr.
Alam Mopang Au.
Alam Wapangao appears for the Food Corporation.
Yes, yes, ma'am.
Appears for the Food Corporation,
Kindly give me 2 weeks, my lord.
and he prays for 2 weeks' time to file his counter affidavit. Prayer made is not objected to by the counsel for the petitioner. List accordingly.
Thank you, Honor.
May I please, your lordship, I beg to mention item number 29. Your lordship, I'm appearing on the instruction of my senior, Nityo Koza, counsel for the petitioner. We have received instruction to file affidavit in reply. Please allow us 1 week time to file the same.
Prayer is made on behalf of the counsel for the petitioner. On behalf of the petitioner that 2 weeks' time be granted to file affidavit in reply. Prayer is not objected to by the counsel for the respondents. List accordingly.
There is an interim order.
Interim order passed early will continue.
May I please, your lordship, I beg to mention item number 27. Here state is yet to file affidavit, your lordship, so kindly grant me 3 weeks' time.
What about the counsel for petitioner? You have not.
Your lordship, I have taken his consent.
Counsel appearing for the state prays for 3 weeks' time
Yes, your lordship.
to file counter affidavit. Prayer not objected to by the counsel for the petitioner. List after 3 weeks.
Your lordship, similar prayer for item 31 also. Here state is yet to file affidavit.
Item
So-
31, similar order.
Your lordship, and similar order for item 33 also. Here also state is yet to file affidavit.
33.
Yes, your lordship.
Yes, you're appearing for any
Your lordship,
Pardon?
I on behalf of counsel petitioner Anungna Longkumer,
which matter?
compassionate appointment.
No, no, which item number?
Item number 33.
33. Any objection to the prayer made?
No objection, your lordship.
Prayer not objected to by counsel. Yes,
Much obliged, your lordship.
May I please, your lordship, here in item 31, lordship, there is two analogous matter, lordship. So if these two WPC can be clubbed along with this matter, lordship. WPC is
it
176.
is submit in item 31. Counsel for the petitioner submits that there are two analogous matters which may be listed together. Accordingly, this matter along with WPC,
176 and 178 of 2024, lordship.
76 and 178
Lordship.
of 2024. Let all these three matters be listed together.
Much obliged.
May I please, your lordship, I beg to mention item number 32. On behalf of S. Mary, lordship, kindly grant 3 weeks' time to obtain instruction.
And what about the petitioner? Petitioner,
Lordship, we have no objection, lordship.
item 32, 3 weeks' time granted to the state respondents to file their counter affidavit.
Lordship, to obtain instruction, lordship.
Obtain instructions and file affidavit if so advised. In terms of the prayers made. So prayer made is not objected to by the counsel for the petitioner, list accordingly.
I oblige.
For motion, item numbers 1 to 3.
Yes,
This is your lordship. Your lordship, the petitioner's firm has been, the item number 1. Petitioner firm has been blacklisted, my lord, after the contract period has successfully concluded. Almost 3 years after the contract period has concluded, your lordship. The second point, your lordship, is that now there is an arbitration agreement and the arbitration proceeding is also about to begin. So, my lord, as far as the settled law is concerned, my lord is aware that blacklisting is bad in the eye of law. Number 1, when the contract period has successfully concluded, and they have also given us a certificate certifying that we have successfully and satisfactorily performed. And after the conclusion of the contract period, we were blacklisted. Arbitration is about to begin. Arbitration petition is also pending, my lord.
Arbitration with regard to the earlier contract.
Yes, your lordship. So there was a dispute that arose. So, my lord,
There was a contract given to you
my lord.
that according to you was completed.
Not just according to me, my lord, by their document also, your
Right,
lordship,
it
my
was
lord,
completed,
my lord.
but in that contract, there is some dispute which arose
Yes, my lord,
for which there is an arbitration clause, so the matter needs to be
my
referred
lord,
to or
your lordship,
referred to arbitration.
my lord.
But in the said contract, now they have issued a notice for blacklisting you.
Not just,
Debarring.
yes, your lordship, and I'm already debarred. And the name in the website of the Airport Authority of India, my lord, it has greatly tarnished not just the image of my client, but the business opportunities is also greatly affected. So, my lord,
It's, you have to be heard
my lord,
whether the debarment blacklisting is as per the
my lord,
principles laid down.
your lordship. So, my lord, in this short period, window period, my lord, may kindly stay the operation of the debarment so that we can prepare for a proper argument. I'm ready, but I do not know whether my friend is ready for
But
argument or not, your lord.
debarment notice is already, debarment order is already issued.
It's already issued and it's on the website. It has affected the business of my client, my lord.
So staying it is not going to give you any benefit because giving an interim stay
My lord,
of an order which is issued to the extent of being blacklisted will amount to giving you the final relief because that is ultimately what you are praying for.
my lord.
So we can issue a short notice and you may, if the
Yes,
records are available, we can peruse the records and hear the matter or some other day.
Then can we hear it in a few days if my learned? Yes.
May I please, Lordship?
Yes,
Your Lordship, I'm entering appearance on behalf of the respondents in item number 1, Your Lordship.
which respondents?
All the respondents, Your Lordship.
Airport Authority?
Yes, Your Lordship.
Yes.
Your Lordship, we have just received the notice. Your Lordship, a week's time may be granted. I've already received the instructions, Your Lordship, and we will be filing our counter affidavit within a week, Your Lordship. As such, I'm praying a week's time may be given. And all the three, item number 1, 2, and 3 are analogous matter. A fixed date may be given, Your Lordship, so that all the three matters can be disposed of, Your Lordship.
My lord, as far as if my lord may kindly allow me, as far as the item number 1 is concerned, it directly affects the livelihood of a person, my lord, when business
then-
opportunities are all
That's all
affected,
right, but
my
then,
lord,
giving you an interim order today.
my lord, your lordship.
The order has already been issued.
Yes.
Right. It is not a case that the order is in the pipelines
My
likely to
lord.
be issued.
Your lordship.
It's already issued. So if we stay the order, it will amount to giving you a final relief.
I got your point, your lordship. So, my lord, in that case, respecting the position that order has already been issued, my
We
lord,
will issue a very short notice making it returnable next week since the councils are represented.
your lordship.
And you want 1 week's time to file your counter, madam?
Yes, Your Lordship. Yes, Your Lordship.
So let it come a week after next.
My lord.
Your
And
Lordship,
my
I'm
lord-
humbly, Your Lordship, I'm humbly saying a fixed date may be given so that I will come
We
physically
are
and,
giving you a fixed date.
yes, Your Lordship.
You will fix it on 28th of November. Is that good for you?
Yes, Your Lordship.
Yeah.
Yes,
My
Your
lord.
Lordship.
That's a 27th, your lordship.
27th is the. due
Tuesday?
bench.
Yes.
No, 27th is a Wednesday. You can have it on 26th.
26th.
Yes, Your Lordship.
26. Yes, my lord,
Tuesday.
26.
Right, heard. The Shaki Learned Counsel for the petitioner. And your name, madam?
Priyana Chetri, Your Lordship.
Priya
Priyana Chetri.
Chetri. Okay.
Yes, Your Lordship.
Next, Wednesday, Learned Counsel appears. Along with, you are also appearing?
I'm appearing in item number 3.
Appears on behalf of all the respondents. The writ petition is directed against the debarment notice, debarment order issued. Where is the order? What is the date of the order?
Annexure 22, my lord. Page
This is 11/9.
11 September
Yes, Your Lordship.
2023.
11/9/2023 by the airport authority, whereby the petitioner was petitioner was debarred from participating in any tender / RFP floated by the Airports Authority of India for a period of 3 years from the date of issue of this letter. And also the EMD submitted by the petitioner with respect to the same tender was forfeited. Stop. It is submitted by the learned counsel for the petitioner that this debarment order came after successfully executing a contract which was granted to the petitioner by the airport authority. And therefore, the same could not have been done after successful completion of the said contract. And a certificate to that effect was also issued by the airports authority.
My lord.
Stop. He submits that the effect of the debarment order has virtually affected his rights under Article 19 to pursue any trade or business, as he is unable to participate in besides any tenders offered by airports authority, other similar public sector undertakings, as no authority will shortlist the petitioner in the face of the debarment notice issued by the airports authority. He submits that this is contrary to the position in law established
My lord.
pursuant to Eurasian
Your Lordship.
judgment of the apex court reported in so and so. So he therefore submits that this debarment notice be set aside and the EMD forfeited be refunded back to the petitioner, and he be permitted to participate in all tenders that he may seek to apply for. And during the pendency.
My apologies, Your Lordship. EMD issue was also not there, Your Lordship, because it was
It's
closed
there in
long
the
time back.
order.
My lord.
There in the order.
Yes, there in the order, my lord, but it's just written here. It was closed long time back, Lordship. It is not that they have.
You strike
Yes, my
out
lord.
the EMD
My
part.
lord, Your Lordship.
He therefore submits that during the pendency of the writ petition, adequate interim order suspending the debarment notice be issued to the petitioner. Where MS so and so appearing for the respondents submits that her instructions are complete. She requires a week's time to complete all instructions and file counter affidavit if so advised. She submits that at this stage interim order may not be issued, and the matter be heard after the counter affidavits are filed by the respondents. Stop. Accordingly, since the councils are represented, parties are represented before this court, let a notice be issued, making it returnable on, you said 26th,
My lord, make it 28, my lord.
28th November 2024, by which date the respondents are permitted to file the counter affidavit and serve advance copies to the counsel for the petitioner. Stop. Petitioner is granted liberty to file a reply affidavit if so advised. Stop. Issue notice on the stay prayer, making it returnable on the same date. Prayer for interim will be considered after filing of the counter affidavit on the next date fixed. List accordingly. Since the council is already represented, notices are waived. Extra copies be furnished within the course of this week.
My lord.
Can you furnish copies
Your Lordship.
by tomorrow?
Perhaps my learned friend, the lady, can have colleagues here also.
Yes, Your Lordship.
Who you can serve with, my
That's
lord.
for both of you to find out.
My lord,
Don't
your
come to the
lordship.
court on that.
My apologies, your lordship.
Notices are waived, our extra copies be furnished within 3 working days,
My lord,
right? This last line, you put it before the, the date we have fixed the matter on so and so. That should be the last line, all right? Yes, all right. Now, item number 2.
Your Lordship, in item number 2, I'm appearing on behalf of all the respondents. Your Lordship, I've already filed my counter affidavit. Your Lordship.
your lordship, in the arbitration, when the matter was taken up before the learned court below, the district and session judge Dimapur, the district judge Dimapur, since he has no authority to appoint the arbitrator, and the airport authority of India, they came with a list of arbitrators of their own choice. And my lord is aware of the settled principle of law that if they want to have bring an arbitrator of their own choice, we do not trust. So we want a neutral arbitrator. And the court below does not have the authority to appoint an arbitrator. That's why this petition before this honorable court.
Yes,
Your Lordship, we don't have any objection, Your Lordship, if this honorable court appoints an arbitrator, Your Lordship, as the subject matter of the petition is the department list, Your Lordship, the department letter. As such, I don't have any objection if this honorable court appoints arbitrator.
So, my lord,
have you had issued notice on the petitioner earlier?
yes, your lordship, your lordship.
So they declined to appoint an arbitrator? Or they suggested the names?
They suggested their choice of names, which
You did not agree.
we did not agree, your lordship.
Now, do you have any suggestions?
My lord, as of now, I have not asked my client, but we would prefer any name that is suggested by the honorable court.
Where is the seat of arbitration? Where is it? Where is the seat?
Lordship, it should be in Dimapur.
Dimapur.
Yes, your lordship.
Dimapur, Your Lordship.
What was the agreement first? Where is that?
Your
agreement?
lordship, the arbitration clause is at page 37 of the contract agreement. May I read, my lord? Arbitration clause. All disputes and differences arising out of or in any way touching or concerning this agreement, except those the decision whereof is otherwise herein before expressly provided for, or to which the Public Premises Eviction of Unauthorized Occupants Act and the rules framed thereunder, under which are now enforced or which may hereafter come into force are applicable, shall in the first instance be referred to a dispute resolution committee set up at the airports, for which a written application should be obtained from the party and the points clearly spelled out. In case the dispute is not resolved within 45 days of reference, then the case shall be referred to the sole arbitration of a person to be appointed by the chairman/member of the authority, that is the airport authority, my lord. The award of the arbitrator so appointed shall be final binding on both parties. The Arbitration and Conciliation Act 1996 shall be applicable. Once the arbitration clauses has been invoked, the DRC process will cease to be operative. It will be no bar if the arbitrator appointed as aforesaid is or has been an employee of the authority, and the appointment of the arbitrator will not be challenged or be open to question in any court of law on this account. Acceptance or challenging arbitration award by CHQ shall be done after obtaining the views/recommendations of the concerned REDAPD RHQ Gauhati in consultation with law department.
Right. Are you aware of a notification issued by in the principal seat about the names of a few arbitrators, the panel?
No, no, my lord.
So we'll appoint an arbitrator from that list.
My lord,
I don't know if it will here, but we'll requisition from the principal seat.
lordship.
there is a notification issued by the registry of the Gauhati High Court, notifying a panel of arbitrators. We will appoint an arbitrator from that list.
Your lordship.
So do you have the list of arbitrators, panel of? You talk to the registry. If they don't have, they can get it from the principal seat by email over. Yeah, right now, because you inform them and all right, we'll appoint, what is the value of the contract here? Where's the agreement you said?
Your lordship, the agreement starts from page 23.
What was the contract about?
Your lordship, this is for running a cafeteria stall at vehicle parking area at Dimapur Airport, Nagaland, page 23, my lord. The second para, my lord. Whereas the authority is entitled in law to grant license at its airport for the purpose of license for operating cafeteria stall at vehicle parking area at Dimapur Airport, Nagaland. Then, my lord, may kindly come to paragraph 7. May I take your lordship to paragraph 7, page 25?
Yes.
The licensee has deposited an amount of rupees 66,000 FDR number so and so dated 25/4/2018, equal to 6 months license fee as a security deposit. So, your lordship, as far as the total amount is concerned, since this is a sales services, the actual amount of contract, my lord, it cannot be like other contract work.
All right, I propose to appoint Justice Hukato Su, former judge of this court,
My lord,
because your seat of arbitration is in Dimapur.
my lord,
So, subject to he giving the declaration under 12.
your lordship,
So, we'll pass orders accordingly.
my lord,
Okay?
my lord.
We are not disposing of this petition. There are two ways we can do it. We can close this petition, appoint Justice Su, subject to his disclosure under section 12. For some unforeseen reason, if he's unable to take it up,
My lord,
then you again need to think of appointing some other arbitrator.
your lordship,
So I think we'll appoint Justice Su, calling for his disclosure. And we'll keep the matter after 2 weeks or so.
my lord, maybe listed on the same date, 28, my lord, your lordship,
Yes.
my lord,
And on which date, if you can get a disclosure, the court concerned will close the appointment.
my lord,
Right?
your lordship.
You heard? Learned counsel for the petitioner. And you are appearing for the respondents?
Yes, Your Lordship, all the respondents.
MS Chetri, learned counsel appearing for the respondents. This application is filed under section 11, the Arbitration and Conciliation Act 1996. The petitioner was awarded with a contract awarded with a license for operating a cafeteria at the car parking area in Dimapur Airport, Nagaland, by the Respondents Airports Authority of India. Stop. The license was issued on 18/4/2018. Stop. The period of contract is for 2 years.
Yes, your lordship,
for 2 years. The pursuant to the award of the license / the contract, petitioner proceeded to execute the contract. And the agreement was duly executed by and between the petitioner and the airports authority. So in clause number, where is the arbitration clause?
Your Lordship, page 37.
This is the part of the agreement.
Yes, Your Lordship. This is exit clause number E, my lord.
As per the clause number, as per the clause, as per the exit clause
My lord.
of the general terms and conditions, in cases of disputes and differences arising out of or in any way touching or concerning this agreement, the dispute shall at the first instance be referred to a dispute resolution committee. Stop. And if the dispute is not resolved within 45 days of reference, then the case shall be referred to the sole arbitration of a person to be appointed by the chairman / member of the authority. So, was it referred to dispute resolution?
But we never agreed.
It was, yes, Your Lordship, it appears it was referred, but the
Well-
parties did not come to an agreement.
It is submitted by the learned counsel for the petitioner that the dispute, the dispute was referred in terms of the said clause to the dispute resolution committee, which however could not resolve the disputes between the parties. Stop. Consequently, the respondent authority furnished a list of the panel of arbitrators, which the petitioner, from which the petitioner was required to select and appoint, select and choose the arbitrator. Stop. The learned counsel for the petitioner submits that the conduct of the respondent authorities in attempting to persuade the petitioner to choose an arbitrator is violative of Section 12 of the Arbitration and Conciliation Act. And in terms of the recent judgment laid down by the Apex Court in Central Organization for Railway Employees, a larger bench of the Apex Court decided the issue and the matter is no longer res integra. Stop. In terms of the said judgment, in view of the provisions under clause 12 of the 12(5) of the Arbitration and Conciliation Act, if the person, if the contractor refuses to agree on any or all of the panel of names furnished by the employer, then and if the parties cannot agree on appointment of an arbitrator, then it is the court under exercise of powers under Section 11 of the Arbitration and Conciliation Act to appoint an appropriate arbitrator. So the position of law is not disputed by the counsel to the respondent. But in view of the recent law laid down by the larger bench of the apex court, authoritatively holding that unless the contractor agrees to the waiver clause and selects any arbitrator from the panel furnished by the respondent authority, then the employer cannot compel the contractor to agree to any of the arbitrators from the panel furnished by the employer. Stop. Under such circumstances, the petitioner, having approached this court under section 11 of the Arbitration and Conciliation Act, this court considers it an appropriate case to exercise its jurisdiction and appoint an arbitrator. Stop. Better. Under provisions of section 11(6), this court, in the facts and circumstances of the present proceedings, considers it appropriate to appoint Mr. Justice Bukato Su, former judge of the Gauhati High Court, as to act as a sole arbitrator to resolve the disputes between the petitioner and the respondents. So his appointment, however, is subject to the disclosure of the learned prospective arbitrator, as is required under section 12 of the Arbitration and Conciliation Act. So the parties are permitted to place a copy of this order before Mr. Justice Bukato Su, former judge of the Gauhati High Court, and apprise the learned prospective arbitrator about the order of the court. So the learned arbitrator may proceed to arbitrate, to act as an arbitrator to resolve the disputes between the petitioner and the respondent upon furnishing the necessary disclosure as required under section 12 of the Arbitration and Conciliation Act. Stop. Accordingly, let the matter be listed again on 28th of November, enabling the parties to place the disclosure as may be issued by the learned prospective arbitrator sought to be appointed by this court, and place it before the court. The order confirming the appointment of the arbitrator will be passed upon receipt of the disclosure. List on 28th.
My lord.
Then number 3.
Your lordship, the item number 3 is a challenge to the interim order passed by the learned court below. But my lord, as far as that order is concerned, your lordship, I fairly admit that it is not enforceable in law in as much as the interim order has been passed. But since it is a related matter, I beg your lordship to kindly list it together with the other matters on 28.
Item 3 also listed on 28 or 6? 28.
28.
Yes. Who's appearing for item 3?
I'm the revisionist. You know,
You're appearing for
all the four
all the 4 respondents.
petitioner.
Here I'm the respondent, your lordship.
So here you're the respondent.
My lord.
Item 4, learned counsel.
Item
Mr.
3.
VMK.
Appears for the petitioner, Mr. Sheki for the respondent.
My lord.
Is airport authority also party in item 3?
Here they are the revisionists.
They are the petitioners.
Yes, yours.
All right.
Oblige, your lordship.
For motion, item number 4.
Yes.
Please, Lordship. Lordship, now I'm coming before the Honorable Court, challenging the immune termination order, Lordship. Now, Lordship, the petitioner was appointed as a sectional assistant work charge. And now almost 28 years completed now. Now, Lordship, what happened, Lordship? For some few months, the salary was not given. So the petitioner has made a representation for the release of the salary. Now, the non-consideration of the representation, the petitioner approaches honorable court, and then this honorable court has disposed the matter in the earlier petition by directing to consider after verification. Now, Lordship, what happened after the verification was done? Out of this 46 months, only half of the salary, maybe 22 months, was given to us, Lordship. Now, at the time of giving the salary, my service was terminated by a command order, Lordship. And now, Lordship, what happened? I want to make a little facts on that, highlight about that. Lordship, what happened is that the impugned termination order was signed on 9 August. And then the order was given to me on 25th September because my salary, 22 months salary was given on 25th September. And then on that same day, the termination order was given. And then in the order, it was that effective with 1st January 2024. So the order was thereby dishonestly and then given arbitrarily given to me. Now, Lordship, I'll take to the impugned termination order. Lordship may kindly turn to my termination order, Lordship. That is page 33, Lordship, annexure 5. Lordship, page 33, Lordship. So, Lordship, I may allow only the relevant portion, how they have issued the termination order. List of particulars of the government servant released from duty in terms of Rule 5 of CCS under bracket DS Rules 1965, as per the terms of the appointment agreement, the work charge staff under Executive Engineer BW Housing Division AH and Veterinary Services Kohima, Nagaland is hereby terminated with effect from 1st January 2024, as I have highlighted. Now, Lordship, when they have quoted this section, I have already stated in my petition, Lordship may kindly if your Lordship may kindly see my statement, as I have categorically made statement at paragraph 10. What the Lordship, paragraph 10, I may be allowed to read.
Yes.
That the respondent authority has issued the termination order dated 9 August 2024 as per the terms of Rule 5 of the CCS under bracket DS Rules 1965, and from more clearly the said Rule 5 of the Central Civil Service CCS, Lordship, it means the Central Service Civil Services Temporary Service Rules 1965 is herein quoted as follows. Now, what the Rule 5 says, Lordship. Rule 5 of the Central Civil Services Temporary Services Rules 1965 deals with the termination of a temporary employee services. Now, in that, it is clearly given that the government can terminate a temporary employee service immediately by giving a man notice. They have taken the shelter of Rule 5. So when the Rule 5 is very clear, no notice was given to me, and then even the way they have issued the termination order to me, it is behind the back, Lordship, I should say, because and then dishonestly, and then the order was given only on the 25th of September, whereas it was signed, Lordship, on 9 August, Lordship, and then the effective date is the 1st January of 2024, Lordship.
So for today, we'll issue a notice, let
Lordship.
the respondents come with their instructions.
Lordship, and then what moreover that I may be allowed to submit on further submission, Lordship. In all the departments, I'll be submitting some additional affidavit because in the same department, some work charge employees are still exist. Now, in all the other departments, work charge employees were appointed, and then the government of Nagaland has promulgated a scheme. So, and then on that scheme, Lordship, several notification has been issued for observation how the work charge employee will be observed for regularization after observing certain scrutiny tests, this and that. No, Lordship, I'll not, I'll take Lordship to that is petition, and next year, if your Lordship may kindly turn to my page 40. This is one of the scheme office memorandum, Lordship. Verification of work charge and casual employees follow-up action thereof. Not Lordship. The second page, Roman 5. I have given the type copy at page 42. So
Yes.
Lordship, now I'm even allowed to read in this Roman 5.
Yes.
In cases where disagreements like appointment orders, extension order, etc. are not available, the department concerned may furnish the requisite document within the period of 1 month from the date of issue of an OM. Further notice for termination of service of the bogus duplicate overage employees may be issued given 1 month notice for reply to a concerned employee. So in the work charge office memorandum itself, it is clear that a work charge employee may be given if there are found to be some irregularities. A 1 month time may be given. But here in my guest, no such procedure was exercised. Moreover, Lordship, I'm serving in the department for more than 28 years. No opportunity was given, which is also against the principle of this natural justice, Lordship, as I have already stated in my petition. So, Lordship, in a very simple way, Lordship, that I have asked for salary. And then they have also admitted that I should be given my error. That is why they have given me the 22 months, leaving another 24 months, Lordship. So when I was expecting the remaining.
When was the termination order issued?
Termination
Yes.
order, Lordship, termination order was issued on 9 August 2024. And then, Lordship, as I already pointed out, on 25th, I was giving the 22 months error salary. And then on that day only, they have given me this termination order. And then when we see the termination order, it is effective from 1st January 2024, Lordship. So all these are, Lordship, it's not fair, Lordship, unjustified.
Your area salary is from which period to which period?
Lordship, I have given the statement, Lordship.
Page number?
Lordship, page 32.
32.
So, Lordship, my salary was given as per the Honorable Court direction after making some certain verification. And then this is the statement, Lordship. So it is start from
Up to September 2022.
Lordship.
So from October, you have not got your salary.
Lordship.
And you were terminated in August.
Yes, August. So that is how they have issued the unjustified, unreasonable termination order. And then, Lordship, I have approached this Honorable Court for this grievances, Lordship. And Lordship, in lieu of that, my humble submission is that this is a dim fit to grant me the interim order in this.
What interim orders you were asking for?
Lordship, for a stay of this interim order, Lordship. I have two prayer, but
This stay of the impugned order,
Lordship.
you see, pursuant to the order being served, pursuant to the orders being served,
Lordship.
you're required to hand over charge or what?
No, Lordship, see, I am.
You, from the date you are appointed, you go to
Yes.
the office,
Yes,
you're supposed to get a salary.
yes,
But for these 22 months or whatever, they did not pay your salary. You
Ye-
worked.
yes, Lordship. Till now, I'm working, and Lordship.
All right.
So, Lordship, see this, I'm giving my best
You're
service.
working- what work are you allotted?
Lordship, I'm working as a work charge sectional assistant. Work charge sectional assistant, Lordship. And then my appointment order, Lordship, if you Lordship may kindly see my appointment order. That is annexure 1. Page 16. And then the type copy is at page 17. So I'm working as a
And
work
this-
charge,
In any case, this order
Lordship,
is of August
Lordship,
2009 to 2024.
Lordship.
We are in November.
Lordship, see, Lordship, I tried my best to approach this Honorable Court, but due to some preparation, and then at the same time, the Honorable Court was on vacation on Diwali and then the Puja holiday. That is why Lordship, there was some few days delay, Lordship. So my humble request, Lordship, since I'm working and then at the same time, he also admittedly say that I'm entitled for the salary. But how they have issued the termination order by order itself, they have make a shelter on the Rule 5 of the CCS. But no notice was given, sir. So it is very arbitrary, Lordship, and illegal, Lordship. So my humble submission that if for the interest of justice, Lord, let my interim be kindly considered, Lordship, at this stage.
Because there are two issues here.
Lordship,
One is that you are terminated.
Lordship,
Whether your termination order is legal, illegal is a matter to be decided in the course of the hearing.
Lordship,
But fact remains that as on date you are terminated.
Lordship,
Now, if we grant you an interim order,
Lordship,
you will continue in your service
Lordship.
contrary to the orders passed by the government.
But Lordship, I'm saying that the order is illegal, Lordship. Yes, yes, yes.
Today, we can't say it is illegal or illegal.
Lordship,
Yes.
Lordship.
So if we grant you an interim order and the matter goes on for 1 year or 2 years or 3 years, assuming,
Yes, Lordship.
then on a day when subsequently you may start claiming the back wages that I work, there's an interim order, you pay me my salary. That danger is there.
Lordship, endeavor may be made, Lordship, to dispose of within expeditiously, because it's what?
Expeditiously will happen only when the government files their counters.
Lordship.
Time.
And then Lordship, it's a very simple matter, Lordship.
Yes, Mr. Government Advocate, what do you say?
Notice to issue, your lordship.
Notice, right. What about the interim order?
Lordship,
Let
yes.
me find out notice to issue.
Lordship, because as per the termination order, it is very clear, they have made a shelter on this Rule 5. So my humble prayer, Lordship.
Mr.
Esteemed Lordship.
Esteemed Learned Counsel appearing for the petitioner and Mr. Imchen, Learned Senior Government Advocate for the state. You are representing all.
Lordship.
This writ petition is filed by the petitioner challenging the order of termination dated 9th of August 2024, whereby the petitioner and other 24 similarly situated work charged employees were terminated with effect from 1/1/2024. Stop. The petitioner's name appears at serial number 16. Stop. It is submitted by the learned counsel for the petitioner that the petitioners have been working, rendering their best services, their services to the best of their ability since their initial appointment orders. Stop. With effect from December 2020, their salaries were held up. Notwithstanding that, they continue to render their services. Stop. Subsequently, the government, by its order, where is the order of release of salary?
Lordship, we have just given the list,
Where is that page number?
that is a page number, Lordship. Page 32, Lordship. Annexure 4.
The petitioner, the counsel for the petitioner has referred to a document to show that the salaries of the petitioners were released from December 2020 up to September 2022 within bracket 22 months. Where is the name of the petitioner here in this list?
Pardon, please, Lordship.
Where is the name of the petitioner?
Name of the petitioner is at Lordship 16. 16.
16.
It's serial number 16.
It is the submission of the counsel for the petitioner that they were rendering services as work charged sectional assistant under the Animal Husbandry and Veterinary Services
Lordship.
Department, Government of Nagaland. So the counsel for the petitioner submits that as per the office memorandum dated 17 March 2015, the government has instituted a scheme for regularization of services. So the petitioner has been, the petitioner is entitled to be considered under the said scheme for regularization of his services. Stop. That apart, by office memorandum dated 9th of November 2016, a verification committee appointed by the government had submitted its report department-wise. And at clause 5 of the said notification office memorandum, it is provided that where the initial appointment order, extension order, etc., are not available, the person concerned may be permitted a period of 1 month's time from the date of the issue of the said office memorandum to furnish a reply to such notice. Stop. Learned counsel for the petitioner submits that no such notice was issued on the petitioner, and on the day when their 22 months of salary was released, the impugned termination order was also handed over. Stop. It is submitted that this termination order, besides being not warranted considering the services rendered by the petitioner, is also violative of the basic rules of natural justice. So he therefore submits that the impugned order be referred with, set aside, and the petitioner be considered to be still in service, and during the pendency pass appropriate interim orders staying the said termination order as the petitioner is still continuing in his same post. Well, learned government advocate appearing for the state submits that at this stage a notice be issued as he is not posted with the required instruction. Accordingly, upon hearing the counsels for the parties issue notice returnable 4 weeks, since the respondents are represented, all the respondents are represented by the learned government advocate. Notices are waived, but extra copies be furnished within course of the week. Within 1 week.
Lordship. Within 3 days, Lordship. It's ready, Lordship.
All right, within 3 days, 3 working days from today. Stop. The respondents will are at liberty to file their counter affidavits if so advised. So issue notice on the interim prayer, returnable on the same date. On the next date fixed, the prayer for interim will be considered depending on such instructions as may be placed before the court by the department. All right.
Lordship, my humble submission, because I have already stated that those impugned order was issued illegally, Lordship. So it's a fee case, Lordship. And then in
How much
the
time do you require to obtain instructions?
Lordship, for 4 weeks time.
4 weeks.
till the returnable date, Lordship.
So, days.
14th.
So 4 weeks will be Christmas.
Lord, short time may be given prior to that, and then let my humble submission that because I'm working for more than 20 years, and then similar,
Matter be listed on 5th of December.
Lordship.
On which date the prayer for interim will be continued till the next date fixed. If the petitioner is still found to be in service, rendering his service, he shall be permitted to do so. But this will not give you any advantage.
Lordship.
Until we set aside.
Lordship, after the final hearing, Lordship, I'm ready to accept whatever the court, honorable court give the word order. But since I'm not asking for any regularization, but I'm pointing out that
This interim order will continue till the next date fixed or to such other date as the court may desire to extend. Stop. List accordingly on 5th
Lordship.
of December. But 5th of December is Hornbill time. You'll say no instructions, everyone is busy there.
Yes, Lord.
No. Yes.
Obliged, Lord.
For motion item number 5.
Lordship, similar, this is.
Same order.
Yes, same order, Lordship.
You give the name of the person in the
Lordship,
list,
Lordship.
as in the list of termination as well as in the list of the salary.
Lordship.
So this is up to
18, Lordship.
18 similar orders.
Lordship. TPM Lordship.
Obliged, Lord.
For motion item number 19.
May I please, your lordship? This matter is for conducting district level verification and for regularization.
Let me get the brief. Yes. This is for?
This is for regularization. Yes,
You're working as?
I'm working as a laboratory assistant in in the State College of Teacher Education.
You're still working.
No, I'm not working anymore. I've been released from service on the 7th of March. Yes, 31/7/2024.
You want regularization so that you can be considered for pension.
Yes, your lordship.
Right, heard learned counsel. Yes,
Lordship, at this stage, let notice go.
heard learned counsel, MS so and so for the petitioner, and this petition is filed by the petitioner who served as a laboratory assistant in the State College of Teacher Education, Kohima. Since been appointed, since our appointment on temporary basis, ID order dated 16/9/1989. So our services continue to be extended from time to time till her release from service stop. It is submitted that the petitioner served for 35 years without any blame or blemish as a casual employee and was released from service on 31/7/2024. Where is that order? 31/7?
Page number 16.
Okay, no, not sorry. They released on 3006.
The order is dated as 30 June 2023. However,
Page number 26,
page number 16.
16.
So his name will be mentioned on page number 17, serial number 14.
Yes. Petitioner was released from service on 30 June 2023.
Your lordship, he was released on 31st July 2024. But the release order date is 30 June 2023.
How he continued to work for 1 more year, almost?
Because he's due to retire only on 31st July. However, it's just that the order, they have given a common order where they have listed all the people that has to be released.
Okay. He was released from service on 31/7/2024 by an order issued on 3006/2023. Stop. Learned counsel for the petitioner submits that considering her length of service, she ought to have been regularized and thereby enabling her to earn pension for the services rendered. However, for no fault on her part,
Your lordship, it's his.
he, the petitioner's case was not considered by the department appropriately for regularization, and consequently, he was released from service as a casual employee without any pension. Stop. The present writ petition is seeking a direction to the respondents to consider the claim of the petitioner for regularization of the petitioner. For the services rendered. MS so-and-so learned government advocate represents the state, the entire, all the respondents.
Lordship, 1 to 6.
1 to 6.
Lordship.
She submits that instructions are necessary in the matter, and they will submits that the matter be listed. At this stage, notice be issued. Learned councils have been heard. Considering the submissions, issue notice returnable 4 weeks.
Okay, lordship.
The respondents may file the counter affidavit in the meantime, so advised. Steps on extra copies on respondent number.
Be given
of
in the course of the
respondents will be furnished within 3 working days. List accordingly.
I will pledge.
For motion item number 20.
Yes.
May I please, Lordship? Lordship, this instant writ petition is filed for appointment on compassionate ground, Lordship. Her Lordship, the brief make of the case is that the petitioner's father let S. Ole Konyak die in harness on 19/09/2022 while rendering services mason under the establishment of Directorate of New and Renewable Energy, leaving
Yes.
behind his wife, the petitioner, and 2 siblings, Lordship. And Lordship, due to the untimely demise of the petitioner's father, all the responsibilities and burdens falls onto the mother, who is also unemployed. So after the demise of the petitioner's fathers, the petitioner submitted a representation dated 20/09/2022, praying for appointment on compassionate ground, Lordship.
Page.
17, Lordship, Annexure D series. Type copy is at page 18, Lordship.
That has not been considered.
Lordship. Lordship.
When did you submit this? 20/09.
20/09/2022, Lordship. But
Okay.
my
That was by your mother.
Lordship, recommending me.
Oh. Okay.
Now, in Lordship, after that, my representation was submitted on 20/09/2022,
Hmm.
but my letter was forwarded only in the year 2024, Lordship. That is on 23/05/2024 by the director.
Yes.
And in my after my letter was forwarded for proposal for appointment on compassionate ground, Lordship, there is a list of applicant under the compassionate appointment, and my name is at serial number 1, Lordship.
Where is that? Page number?
Page 33, Lordship.
33.
33, Lordship.
Then what happened?
Pangtok Konyak, Lordship.
Yes. Then what happened?
Lordship, despite the lapse of more than 2 years, my prayer has not been considered. So being aggrieved, the petitioner has filed this instant writ petition, Lordship.
Yes, respondents
Lordship, at this stage, you can.
heard counsel to the petitioner. This petition is directed, praying for an order from this court to the respondents to appoint the petitioner under the compassionate scheme in a post found suitable. So the petitioner's father, late Ole Konyak, who was serving in the, under the Department of New and Renewable Energy as a technician. Expired on 10th of September 2022 while in service. Stop. An application for appointment of the petitioner was made by the mother of the petitioner, as his late father was the sole earner for the family. So these applications were considered and the petitioner's name was shortlisted. At serial number 1. In a by the Director, New and Renewable Energy, Nagaland, and in a communication dated 25th of May 2024. Stop. However, his case has not yet been considered and left with no option, the present writ petition has been filed. Learned Government Advocate submits that notice at this stage be issued.
Lordship, this matter may be disposed of on this motion stage also, Lordship, because it is very clear that the petitioner is eligible.
Direction to whom?
To the Commissioner and Secretary, New and Renewable, Lordship.
But whether your case was rejected, not rejected, you don't know anything. Nothing has been communicated. Have you received any order?
No, Lordship, no, Lordship.
Right. We close this matter? at this
Lordship,
stage?
I don't have any objection.
Right. Then you write, considering the prayer made in the writ petition, it's seen that the petitioner has a limited prayer seeking a direction to the respondents to appoint the petitioner on compassionate ground under the establishment of Directorate of New and Renewable Energy Department, Nagaland, Kohima, under the scheme of compassionate appointment. Stop. Considering the prayer made and also upon perusal of the documents enclosed to the petition, more particularly the communication dated 25th of May 2024 issued by the Director, New and Renewable Energy, Nagaland, whereby the petitioner's name is shown at serial number 1, and which reflects that 5 years age relaxation under compassionate ground is applicable by the web number AR-8/8/78. So this court is of the view that the matter can be disposed of with a direction to the respondents, more particularly respondent number 3, 4, no, number 2.
She, Lordship, respondent.
3 is personnel.
Or respondent number 2, Lordship.
Respondent number 2 and 4 to consider the claim of the petitioner for being appointed under the compassionate scheme in a post which may be suitable, considering his particulars, and thereafter pass necessary orders within a time period. Stop. The direction shall be carried out by the respondents within a period of 4 weeks from the date of receipt of a certified copy of this order. Stop. In the event any orders with regard to the appointment of with regard to the claim of the petitioner had already been passed by the respondents, then a copy of the same shall be furnished to the petitioner. That petition accordingly stands disposed of in terms of the above. Petitioner will file a copy of the certified copy of this order along with copy of the writ petition with all the enclosures before the respondent number two. And thereafter, the respondent number two will dispose of the matter as directed within a period of 4 weeks therefrom. Dispose.
Obliged.
For admission, item number 21.
Yes, open one more window, it's getting a little stuffy.
Your Lordship, I'm
Yes.
appearing on behalf of petitioner for the council, P. Chanda. Here the pleadings are completed, so if this matter may be listed for 19 replacement. And I've taken consent from the CGC.
Yes, I'm here.
Yes, what is the matter?
Your Honor, the petitioner, they filed a petition for appointment on compassionate ground. However, Your Honor, they,
Who's arguing the matter?
P. Chanda, sir.
Then we'll fix it on some other date. Mention is made on behalf of counsel for the petitioner that is not available in court. It is submitted that the pleadings are complete, the matter is ready for hearing.
so, my lord, on 20, can we fix on?
Your Lordship.
Do you want it in admission or hearing?
Hearing, sir. Your
Hearing.
Lordship, yes.
Then we'll have to issue rule here.
Yes, Your Lordship.
Issue rule, since issue rule, matter be listed for hearing on
19th.
19 or 20
19,
of this month?
not at least on 19th as agreed to by both the councils.
My lord, my name will be
Your
reflected.
Mr.
YP Gupta appearing from all the respondents.
Mr. YP Gupta appearing.
CGC.
CGC appearing for all the respondents. Appears for all the respondents, his name be reflected in the cause list by the registry. Yes,
Obliged, Your Honor.
For admission, item number 22.
May I please, Your Lordship? My lord, I'm appearing on behalf of my senior for respondent number 5.
yes.
My lord, by order dated 09/99/2024, this honorable court has directed the respondent number 5 to get instruction to the letter dated 08/7/2024 and receive necessary instruction. Therefore, complying to this order, we have filed our additional affidavit yesterday.
Additional affidavit
Yes, Lordship.
yesterday.
Yes, Lordship.
I'm checking. Learned counsel appearing to the government submits that an additional affidavit has been filed yesterday. The same, however, you're not for the government.
No, I'm for the accountant general.
Oh, appearing for the accountant general. Submits that an affidavit has been, additional affidavit has been filed yesterday. Stop. The same, however, is not available in the case record. The registry is directed to connect the said affidavit and list the case. Next week,
Lordship, in this additional affidavit,
yes,
the service book of the petitioner is not submitted to the accountant general. Therefore, we are waiting for the reply of our letter.
you have filed your additional affidavit.
Yes, Lordship.
So let it be connected. You make your submissions on the next day.
Yes, Lordship.
List this matter again next week. Counsel for petitioner appeal, MS so-and-so, and government advocate for the state.
Yes, Madam.
Obliged, my lord.
For admission, item number 23.
May I please, Lordship? My lord, as directed by Honorable Court. I've received the instruction, my lord.
Instructions.
Yes, my lord. In the last occasion, I was directed to produce the steps taken by the respondent. My lord, next page is the file noting before the BNR, my lord.
Proposal.
Yes, my lord.
So they have sent the proposal. Let us wait for some
So,
time.
my lord, my humble submission is, since the matter is under consideration, so this instant petition may be closed by giving direction to the sufficient time to the respondent, my lord.
Yes,
Lordship, that can be done.
right. Heard the counsel to the parties. This writ petition is directed the writ petition is filed by 8 petitioners who submit that, who contend that they were appointed in 2005 as lab technicians in the post of GD constables in different unit hospitals of Nagaland Police, and had continued to serve as lab technicians against the post of the GD constable due to non-creation of the post of lab technicians. Subsequently, one post of lab technician was created, against which one similarly situated person was appointed and posted at the unit hospital Hisama. Stop. Subsequently, another such post was created and a person was appointed. Stop. However, case of the petitioners were not considered by the department in spite of representations being filed. Stop. The petitioners being aggrieved, filed a writ petition before this court, being WPC 121 of 2019, which came to be disposed of by order dated 13/8/2019, whereby the court directed the respondent number 4, Director General of Police, Nagaland, Kohima, to dispose of the representation dated 23/04/2019, submitted by the petitioners by passing a speaking order within 2 months, speaking order of 2 months, within a period of 2 months from the date of receipt of the certified copy of the order. So the petitioners' representations were disposed of and the department passed an order. The department disposed of the representations of the petitioner in terms of this honorable court's order. Stating that the petitioners who were appointed in the batch of 2005 shall be given the rank of Nayak within bracket grade 3 in their respective unit. Stop. The respective units and branches were directed to take immediate action. However, by a subsequent order dated 9/10/2020, petitioner number 3 was informed that his promotion has been cancelled as he had not undergone the basic training Stop. Similar orders were issued in respect of respondent number 6. Stop. Sorry, petitioner number 6. Petitioners 1, 2, 4, 5, 7, and 8 were verbally informed that they would not be granted the promotion to Nayak. Being aggrieved, they submitted a representation dated 4/5/2022, stating that they were never they were never put up for basic training, nor did they refuse to undergo such training had the opportunity been granted. Stop. Since the petitioners' cases were not considered in terms of the earlier order of the state respondents issued on 17/3/2020, that they will be given the rank of Nayak in their respective unit. This present petition has been filed, praying for appropriate orders. Stop. During the course of the hearing, before this court and after filing of the counter affidavits.
No, my lord, here we have not filed.
Not filed.
All the status report.
The instructions being
Status report.
furnished by the learned government advocate. It was informed that the petitioner's case will be considered for the cases of the petitioners have been considered towards creation of 9 supernumerary posts of lab technicians, and the competent department, namely the P&AR department, Government of Nagaland, is currently examining the issue. Stop. On a further query by the court to place the relevant materials before the court, today the government advocate, senior
Government advocate, yes.
has placed a communication dated 13 November 2024, issued by the Joint Secretary to the Government of Nagaland, Department of Home, enclosing the relevant extracts of the file to state that the Home Department Police Establishment had sent the proposal to the P&AR department for creation of 9 supernumerary posts of lab technician. And the P&AR on examination had sought clarifications with necessary supporting documents by their communication dated 22/11/2022. Stop. These clarifications have been provided on 14/6/2024, and the matter is still under examination. Stop. Learned government advocate submits that the department is taking all steps towards creation of 9 supernumerary posts to accommodate the petitioners as lab technicians, and therefore the said exercise may require a few weeks. Stop. learned counsel for the petitioner does not dispute the submissions made by the government advocate Stowe. Both the learned counsels submit that the writ petition can be closed at this stage with a specific direction to the respondents, more particularly the respondent number two. To expedite the process of creation of the 9 supernumerary posts to accommodate the petitioners. And as and when the same are created, the effective orders for appointment of the petitioners against these 9 supernumerary posts be issued without further delay. Stop. In the event of the appointment of the petitioners, all pay and other service benefits that may be payable to the petitioners should also be released. Writ petition accordingly stands disposed of. The directions contained in this order shall be carried out by the respondents within a period of 8 weeks.
4 months, my lord.
4
It's
months.
4 months.
8
Because
weeks.
from PNR, again, I think,
They
it
expedited.
process.
8 weeks, we are giving you 8 weeks. All right, 90 days from the date of receipt of a certified copy of this order. Writ petition accordingly disposed of in terms of the above.
Macam
For admission, item number 24.
Yes.
May I please your lordship? I'm appearing for respondent number 5, lordship, the private respondents. I've filed my affidavit in opposition on 15th of October. However, I have sought for permission to file additional affidavit, lordship. In reply to the additional affidavit filed by the petitioner, lordship. However, I'm not filing in the additional affidavit filed by the petitioner, but I may be allowed to file additional documents in the writ petition, lordship.
That will be by way of an additional affidavit.
Lordship, lordship.
All right. Any objection to the prayer made? No.
Your
Learned
lordship,
counsel, yes.
as per the last order, 8/11/24,
Yes.
state was asked to get certain instructions, your lordship, but since the I've applied for the CTC order also, but since the order has not been uploaded, it could not be communicated to the department. So if some time can be given.
Which order? Court order?
Yes, your lordship, court order dated 8/11, wherein state was
7/11.
7/11. Yes, your
Ah.
lordship.
Not uploaded.
Yes, your lordship, it has not
Should
been
be
uploaded.
Should have been uploaded. All right, we find out.
Yes,
We
sir.
find out from whoever has typed out why it has not been uploaded. Learned counsel appearing for the respondent number 5
Lordship.
submits that she'd like to bring additional documents by filing an additional affidavit. Prayer made is not objected to by the counsel for the petitioner. Learned government advocate submits that further time be granted to obtain the instructions in the matter. List accordingly after
3 weeks, lordship.
3 weeks.
Obliged, lordship.
Interim.
Interim order will continue.
Obliged, lordship.
For admission, item number 25.
It's typed out by Sandeep, but I don't know why it is not up to the 7th. He signed it. Yes, yes. What do you say?
Your lordship, here I'm yet to receive affidavit in opposition.
Who's for the respondent?
Is Mumi.
He is Imumi. The government.
Yes, your lordship.
Where is the counsel? Learned counsel for the petitioner appears before the court. However, none represents the respondents. As per the earlier order, The affidavit in opposition was directed to be filed. However, the same has not been filed as yet. Further 2 weeks' time is granted to the respondents to file the affidavit. But who will inform the government council?
Your Lordship, I'll do. Lakshmana.
Copy of the, since the government council is not present in court, copy of this order be marked to the office of senior government advocate.
Item number 26.
Yes, no affidavit.
Yes, Lordship, both the state and union, they didn't file the affidavit.
Right, same order. Placed after 2 weeks.
Obliged, my lord.
For admission, item number 28.
Lordship, as per the direction I have received an instruction,
What is that instruction? Courtmaster instructions. Yes, what does it reflect?
Lordship, as per the list given to me this morning, my name is reflected at serial number 73, Lordship. Now, I don't know how my name ended up at serial number 73 because in 2020, Lordship, I was serial number 18. Now in 2024, I am serial number 73, Lordship.
73.
Yes, Lordship. And Lordship, if my Lord can kindly peruse Annexure 10, Lordship. 10 and 12 are important, Lordship. They are connected.
Page number?
31. Page number 32 is the type copy of Annexure 10. This is the verification of employment. Here, the name of 3 persons, 3 applicants are listed, Lordship. I may be allowed to read this, Lordship. Find herewith the letter received from TIG headquarters Nagaland, white letter so-and-so dated 28/1/2020 regarding verification of employment of candidates for compassionate appointment in place of deceased officers and personnel of the department. In this regard, you are directed to obtain the required information as desired by the higher authority as mentioned in the letter. Serial number 1, Lordship, the names are important here. 1, Muhammad Abdul Hafiz Chowdhury, Lordship. 2 is the petitioner. 3, Lordship. Now, Lordship, this serial number 1, if I'm not mistaken, his case was disposed day before yesterday by your Lordship, directing to appoint him within a period of 2 months, Lordship. Now, Lordship, if my Lord can kindly turn to page 35, Annexure 12.
Yes.
The type copy is at page 36.
Yes.
Lordship, so the last paragraph, Lordship. However, during inquiry, it was ascertained that Mr. Chang Tselong, that is the serial number 3, the applicant 3, Lordship, son of so-and-so, has been appointed as constable under bracket Taylor on 1/7/2019 in 2nd NAP Alichen Mohokchong. So, Lordship, the person who was listed below me, the applicant, they have already been appointed way back in 2020, Lordship, as per this document, Lordship. However, Lordship, the serial number 1 and 2 are yet to be considered till that, Lordship. Of course, Lordship has already passed the direction, Lordship, day before yesterday, in the other petition, directing the serial number 1 to be appointed within the period of.
Do you have a copy of that order?
No, Lordship. No, Lordship.
Then you are not, you should bring it on an affidavit. Otherwise, this particular.
yes, Lordship, I received this morning.
No, you bring it on an affidavit.
Okay.
Because this lease does not contain any indication. Who has prepared this lease? Who has supplied you?
Yes, Lordship.
It must be duly forwarded by an official letter. Somebody must authorize it. You bring it on record positively. Yes?
Now, Lordship, my application for compassionate appointment has been pending, Lordship, since.
No, we know that, but
yes,
what we want to do is to get this list on record.
Yes,
so
Lordship.
that some effective orders can be passed to verify how your name has been going up and down.
Yes, Lordship,
Right.
Lordship, Lordship. But
Otherwise, we can close this petition with a direction to consider your application, etc. But
yes, Lordship,
then they will consider, say that your seniority wise, you're not included.
now, Lordship, there's a concern that I want to express, Lordship. Filing of affidavit, I leave it to my Lord's wisdom, Lordship. But here, it appears that they have no intention of appointing me, Lordship. Because,
Therefore, we wanted them to.
yes, Lordship, yes, Lordship. And quite recently, Lordship, this honorable court was pleased to quash and set aside 935 illegal appointments of the police department, Lordship. So I believe this is a very good chance. Now is a good time.
900 is okay, but compassionate
So,
appointment
yes.
is not by way of regular appointment.
Yes, but there is a certain percentage, Lordship. So, yes. So I believe,
Whether 900 plus constables have been, their appointments have been struck off or not.
yes, Lordship.
This percentage is fixed. If it
Yes,
is
Lordship.
available, you can be appointed.
Yes, Lordship, Lordship, my
But
Lord.
this will depend on the, according to them,
Yes. So I want to catch that pass.
position of the seniority.
Yes, Lordship. So if my learned friend can promptly file,
That's right.
yes,
I don't know how prompt he can be, but you bring it on record,
Lordship.
or we'll have to call for the original records from the police department.
Oh, Lordship.
Please convey to your clients.
a week's time may be given, Lordship.
Our learned counsel for the petitioner, as well as for the counsel appearing for the respondent. The pursuant to the earlier order passed, learned government advocate has placed before the court a chart reflecting the names of all the persons under the police department presently awaiting to be appointed under compassionate scheme. In the said list, the name of the petitioner appears at serial number 74.
73, Lordship.
73.
Yes.
The name is.
Yes, Lordship. Port 7 it is listed twice, Lordship. In fact, so many of the names are listed twice.
Okay, okay.
There is double numbering.
73. Stop. However, learned counsel for the petitioner on perusal of the said list disputes the veracity of this list and submits that earlier, in which year your name was at serial number?
2020, Lordship.
2020.
Yes, Lordship.
His name was shown to be at serial number?
18, Lordship.
18. Where is that page?
Annexure 10, page 31, Lordship.
21.
Page 31.
31.
Page, that serial number is mentioned at page number 35, Lordship.
35.
Yes, Lordship. I'm sorry, I am at serial number 19. Not 18. 18 is the.
35.
Yes, page number
35
35.
is something else. The serial number, this is not 35, this is 27. You're at serial number?
19. Yes, Lordship.
19.
Lordship, here, out here, district, they also maintain the roster list, every district. And it compiles and it come up to the head of department and they arrange according to that, Lordship.
You bring it on record, whatever you have to
Lordship.
say. He submits that in the verification of employees, in respect of verification of employees, a communication was issued by the Deputy Inspector General Police within bracket HQ headquarters to the Inspector General of Police, SP Kohima, SP of the concerned district and Commandant of the concerned battalion, a list was enclosed showing the names of the candidates whose particulars have been verified. This communication is dated 28th of January 2020.
My Lord.
And in the list appended to the said communication, name of the petitioner is shown at serial number 19. Stop. Learned counsel for the petitioner therefore disputes the contentions of the counsel for the government to submit that when in 2020, his name was already at serial number 19, in 2024, his name could not have been
Serial number 73.
put below at serial number 73 without any explanation as to how the same has gone below. Stop. The learned counsel learned counsel for the petitioner submits that this document, which is placed before the court today, is not certified by the concerned office and therefore is not reliable.
My lord.
Stop. Where, considering the submissions made by the counsels for the parties, and upon careful perusal of the list placed before the court, it is seen that the list contains the name of as many as 175 persons, and the name of the petitioner appears at serial number 73. However, this list, as pointed out by the counsel to the petitioner, carries no endorsement of the department from which this list was obtained, or of the department which has furnished the list. So accordingly, we direct the respondents to bring this list along with all relevant documents by filing a necessary affidavit
Lordship.
within 2 weeks from today.
Lordship, 3 weeks, since I have to receive the instruction and I have to send back to obtain the signature, Lordship. So kindly grant
Lordship,
3 weeks.
Let's take a chance at 2 weeks, Lordship, because if it is 3 weeks and if they are unable to file on the next returnable date, then it will go till next year. The court will enter winter break, Lordship. And this is the case of compassionate appointment where I have been waiting since 2015.
We'll fix it on 5th of December.
My lord.
5th of December. The 6th or 6th of December, we complete 3 weeks.
6th, Lordship.
6th of December,
My lord.
by which time the respondents will file their affidavit as directed.
Lordship.
List again, as around 6th December. Please file it.
Lordship.
Lordship, if it can kindly be on 5th of December, Lordship.
He is praying for 3 weeks. He completes 3 weeks on 5th.
Lordship, on 6th, I may have some difficulties. That is why, Lordship.
Then have it on the next date, on 9th.
My lord.
9th of December. Yes.
Much obliged.
For admission, item number 34.
My pleasure, Your Lordship.
Yes.
Lordship, this matter is for grant of scale of pay. However, the state, Lordship, the state has not yet filed the counter affidavit.
All right, who's for the state? Learned,
On the earlier occasion, Ms. Pichano has appeared.
learned counsel for the learned government advocate is permitted 3 weeks further time to file affidavit in the matter. Let the matter be listed after 3 weeks. Mr.
Manchong Konyak.
Counsel for the petitioner appears. Manjong Konyak
Lordship.
appears for the petitioner. Yes, list accordingly. Yes.
From the supplementary cost list for admission, item number 50.
May I please, Lord Lordship? Lordship, the counsel here for the respondent is not able to reach court in time today because of some difficulties. So if this matter can come up of it,
After 2 weeks.
No, at two, Lordship.
At 2.
Yes, Lordship, after
All
lunch.
right, at 2.
Lordship.
For hearing item number 41 to 43.
Can these matters be completed today?
Yes, Lordship, it's a covered case, Lordship, but there is already a division-based decision, Lordship, which covers the matter, Lordship.
Okay, who's for the respondent?
Yes, my learned friend, she was here in court, Lordship.
You
I believe
inform
so.
the government council? Tell them. Whoever appears, what is the issue here?
Lordship, the issue is that I have worked for 35 years, Lordship, under the Department of PHET, Lordship, as a work charge Kalasi
Then,
since 23/5/1984, and then after serving for 35 years, Lordship, I retired from service on 24/5/2019, Lordship.
yes.
Now, despite that, Lordship, my service was not regularized, Lordship, and so many other similarly situated employees, Lordship, who were junior to me, were regularized. I have also enclosed the RTI information that I have received, Lordship, where in order to satisfy this honorable court that similar yardstick, the same yardstick has not been applied to me, which was applied to the other employees, Lordship. And because of that, my service has not been regularized, Lordship. Now I have also made a representation to the department, which was also not considered, Lordship. Now they have just kept my representation in the cold storage, Lordship. Now, Lordship, so far as this issue is concerned, there are already two division bench decisions. Wherein, Lordship, the decisions passed by the Honorable Supreme Court has also been relied upon, Lordship. And Lordship, if I may kindly place the latest decision. The date of judgment is 6/2/2024.
No, this will require some examination, whether it is covered, not covered, what is the ground. I don't know whether we'll be able to complete the hearing today.
Lordship, I'll be as brief as possible,
No,
Lordship.
you may be brief, but I'll have to understand and then understand to the extent of delivering a judgment.
Yes, Lordship. Then, if I may be allowed to take my lord to the judgment that I have placed.
Yes.
The facts are, Lordship, the same department, identical, Lordship. Here also, Lordship, the petitioner was a work charge employee under the PHED department who has served the department for 35 years, Lordship.
No, you take it up before the next bench available. Because this is a fairly long judgment. One has to go through the judgment to understand what is the ratio.
Yes, my lord.
And whether it is applicable in the facts of your case.
Then, Lordship, if it can be kindly taken up tomorrow, Lordship.
Not tomorrow. Tomorrow is better be listed for hearing again next week.
Lordship, my lord.
See, at your submissions, we can close it.
Yes, Lordship.
But it is safer for the court to go through the judgment, examine the records, and then decide that yes, it is a covered matter.
Yes,
That will
Lordship.
take some time.
Lordship, otherwise it's a simple matter,
No,
Lordship.
simple for you because you are handling it since 21.
Yes, Lordship.
This has come to the court for the first time.
Yes, Lordship.
So we'll require some
Yes,
time to hear this matter. We can hear it, there's no problem.
Yes,
But
Lordship.
all I'm asking is, after hearing, if there are some issues which needs clarification, then the matter goes to some other date.
Yes, Lordship, but if you can take a chance, Lordship.
Yes, what do you say, respondents?
Yeah, otherwise it's a covered case, Your Lordship.
It is covered.
Yes.
By the writ opinion.
Lordship,
By the,
No, by the apex court, your lordship. I'm relying on a apex court order.
which order?
Uh, Civil Appeal number 4223 of 2022. Nishivi case. State of Nagaland and others versus Nishivi.
Lordship,
Where the learned advocate general appeared and said that there is a committee which is being.
No, that is different, your
Lordship, in fact, Lordship, in that judgment that I have placed,
Right.
the Nishivi judgment has been held to be totally not reliable, Lordship. At
This,
paragraph
this
20.
case has been cited, your lordship, in that division bench, but it has not been overruled, your
Can I
lordship.
have a look at the-
Sure, your lordship.
These are two different matters, Lordship. In paragraph
Yes,
20, it has been
yes.
discussed in the judgment.
That's the issue. If it
Yes.
is covered,
No.
it is covered. If it is not, it is not.
Para 4.1, your lordship, I mean, relevant para.
Go to the-
It's a case of a widow seeking the regularization of her husband who died in harness 12 years after the demise of her husband in harness, Lordship. That is why the Supreme Court said that there will be no interference.
Yes.
Yes, Lordship. Now in paragraph 20 of the judgment that I have placed, Lordship, of the division bench decision.
Yes.
Your Lordship, the judgment which the petitioner is referring to is sub judice before the apex court, Your Lordship. State has preferred an appeal against the judgment.
Para 20?
Yes, para 20, Lordship.
Hmm.
I may be allowed to read this, Lordship. Though the learned counsel for the appellants, that is the state, Lordship, here, submits that the findings so recorded by the learned single judge is contrary to the provision of law and also to the decision of the division bench of this court in writ appeal number 27/22, dated 8/6/2023, and also of the Honorable Supreme Court in Nishibi Achumi. This court is unable to record concurrence with the same inasmuch as the factual background of both the cases referred above are different from the facts in the present case. In the case of Nishibi Achumi, the husband of the petitioner had died in harness. The wife, after 12 years of death of her husband, approached the court for declaration of service of late husband, who was working as work charge employee, and also for extending pensionary benefit to the petitioner. Moreover, the deceased employee, during his lifetime, never claimed regularization, and he was much below in the seniority list, and his turn had not come for regularization. Yes. So, Lordship, my case and this case is totally different, Lordship.
That will require examination. That's what I'm telling you. It's not possible to conclude.
Now, Lordship, in para 21, the division bench has referred to two previous division bench decisions, Lordship.
Maybe, but in the face of an apex court judgment.
In fact, Lordship, my case is also covered by the three judges bench decision of the Honorable Supreme Court, reported in 2019, 10 SCC 560, Lordship.
What is the name of the case?
That decision has also been quoted in this judgment, Lordship, of the division bench decision, Lordship. Is it the Prem Singh? Yes, Lordship. Paragraph 28.
Since the matter is before the apex court, let the apex court decide which prevails.
It may not be appropriate, yes, Your Lordship. No.
But Lordship, it has been listed now twice or thrice before the apex court. There is no stay, Lordship, of the division bench decision. So
this will require examination. It's
my
not,
lord,
as simple as you put it, that
Lordship,
it can be disposed of
then
by relying on this.
if it can kindly be listed next week.
If you had pressed for a hearing in the beginning of the week, maybe you would have ventured to look into it.
My lord.
But to conclude a hearing today.
Yes, my lord. I understand.
There are several judgments to be.
Yes, Lordship.
Right. So we post it for
next Thursday, if my lord may kindly please so. 21st of November, Lordship.
Yes, 21st.
I have no issue.
As agreed to by the councils for the parties, let the matter be listed for hearing on 21st of November.
Much obliged, Lordship.
For hearing, item number 43.
May I please, Your Lordship?
Yes.
My lord, the petitioner husband was appointed as constable by Annexure 1. No, Annexure 2. One is medical certificate for the government servant. Page 36, Annexure 2 is the appointment order. I've typed it out in 37. 13 September.
What is your prayer, ex gratia?
My lord,
Extraordinary pension.
yes, in ex gratia.
Is there any government notification?
Yes.
Where is that?
Page 91. This is 14 January 1980.
You fall under which category?
My lord, page 91 is Finance Department, Nagaland.
No, you are claiming under which category?
My lord, my ex gratia, I'm claiming under 93. Huh? Page 93. Annexure 19. This is been here.
This is with regard to overstay service. Regularization of the period of overstay.
93, my lord.
Yes,
93.
93, annexure 19,
Yes.
dated 7th of April.
No. 6th of June.
No.
95.
93
Not the top one. No.
or below, 6th of.
Yes. 17.4.
Okay, 6th of June.
Liberalization pensionary award to the government servant, including IAS and IBAs,
Yes,
IFS, officer killed in action in encounter.
yes.
The question of liberalization of pensionary benefit to government servants killed in action in encounter have been under consideration of the government for some time. After careful consideration of the matter in the light of the recommendation of Government of India, dated 22/9/93, the governor is pleased to order the following liberalization pensionary benefit to the government servant of Nagaland who die in action and encounter, etc. This order shall be applicable to the government servants of all ranks, inclusive of IAS, IBS, IFS, officers of Nagaland cadre.
Yes.
Lump sum, all government servants who have been killed while performing bona fide government duty shall be entitled to ex gratia grant from rupees 1 lakh to 5 lakh, depending upon the nature of duty. Pensionary benefit 3, the family of such deceased government servants shall be entitled to the last pay in allowances, my lord, drawn by the government servant in extraordinary pension. That is as extraordinary pension, and shall be admissible at same rate till the age of superannuation.
No, you're reading from which line? Page 94.
94.3, pensionary benefits, my
Yes.
lord. 3, the family of such deceased government servants shall be entitled to the last pay in allowances drawn by the government servant as EOB, and shall be admissible at the same rate till the age of superannuation of the
Deceased.
government servant, yes.
Yes.
Followed by normal
You're
family.
claiming this.
My lord,
You're claiming this.
my lord, as well as the ex gratia.
Okay.
Then there is another ulang itu. State the Nagaland has notified the direction given by the ministry in the company. 17 lah tadi sabi. 17.9. Yes. Which I've annexed it, annexure 20, page 95. Page 291. Liberalized scheme. Payment of ex gratia compensation in case of death in harness, my lord. Then Government of India,
No, you're reading from page number 17.9, chapter 17.9.
yes.
This is for government civilian employees.
Yes,
Was he a civilian employee?
no. It includes the police personnel law.
How do you say so?
Yes,
So where do you say that? The heading subject itself is for government civilian employees. The notification subject
my lord.
reflects that it is meant for government civilian employees. How do you say it is included for police also? How do you connect?
My lord, 17. Point 7 chapter
Yes.
in 17.6 starts about the liberalization of pension. About those people who died while performing bona fide government service. Company and the
No, what exactly are you trying to make out? Please tell me.
My lord, what I'm trying to
Where is your claim?
make, what I'm trying to see is that
Yes.
as per this ministry leader,
Yes, government has filed their affidavit.
yes, did occurring due to accident in the course of performance of duties is rupees 5 lakhs. That is my page 96.
One minute. Who is the petitioner?
The wife of the deceased. The whole question arose, my lord. I'll come to that point. The petitioner was not the nominee
All
in
right.
the service book. That was the whole issue. The mother was the nominee. For so whatever.
Now, under the pension rules, who is the first claimant?
Spouse
Spouse.
in the children.
Was the spouse employed somewhere?
No,
But now, when the person is there, his service record shows that it is the mother who is to be granted the pension. The department will have to follow that nomination.
my lord, nomination is for benefits only.
Right.
The rule is first is spouse.
No, maybe, but where there is no nomination, here the nomination has been granted.
My lord, nomination has to be for the benefits, whatever other benefits. Pension has to be by the rule,
No, pension is by the rule.
my lord.
But if the pension is by the rule, You have some citations? Some authorities?
My lord,
There are some authorities on this point by the apex court.
my lord, I don't have it.
Then you'll have to bring it.
My lord,
There are some authorities.
If I may be allowed to intervene, my lord, I'm the standing counsel for the Accountant General Office. As far as the office of the Accountant General Office is concerned, no record came to our office, so we are hand tied. But my lord, as far as the practice and the law followed by the state is concerned, in cases where there are disputes like this, a direction is to be issued to the Deputy Commissioner of the district to ascertain on whether she is actually the spouse of the person who has
my lord.
passed away, Your Lordship.
First, before that, you have to ascertain whether under the rules, notwithstanding the nomination,
My lord,
is the claim, the first claim is that of the wife, of the spouse.
no, my lord. It was claimed,
No, it was claimed by virtue of the nomination,
No, it was not claimed.
not claimed.
No.
Then,
Other service benefits has been received by the mother of the deceased. That's all right. Because family benefit in whatever other benefits, it can be given to the nominee, even the GPF
but pension is,
by the rule. That is the whole thing.
what does the rule say, pension rule?
54.
CCS pension rules.
Yes, 1972. That is family pension rules 1964 became Rule 54 of 1974, 72 rules.
Rule 20,
54.
54.
Yes.
Yes.
Family, that is para clause 14. For the purpose of this rule,
Clause 14.
yes, bracket 14.
Yes.
A is continuous service, B is family. In relation to a government servant means wife, Roman one, wife in the case of a male government servant, or husband in the case of a female government servant.
Okay. Yes. Your rule says wife. Then you have to run the pension.
May I please, your lordship, initially when the deceased husband, when he expired the department, it processed the pension papers. It processed the pension papers way back in 1984. Then after that, it was sent to the AG's office. The AG finalized that since the deceased, the constable, his length of service was just 3 years at that point of time. So pension, a family pension was not awarded to them. And only pension gratuity was released to the family. And at that point of time, ex gratia payment was also sanctioned by the government. But here, Your Lordship, it could not be released because there was conflict between the mother and the wife. So at this stage,
What is the requirement for?
Your Lordship, since it was understood that the wife had remarried, the issue was that. So by court order dated 29/7/24, this honorable court directed the deputy commissioner.
What is the qualification for family pension? Completion of 1 year. Why do you say?
This was the AG's letter, Your Lordship,
No,
from
no,
the.
you come to page number, you go through the CCS rules. Do you have a copy of CCS rules?
But Your Lordship,
No, forget the letter. Let us understand the rules first. Do you have a copy of the rules? Give it the CCS rules. You see clause 54. Family pension 1964, yes?
Yes, Your Lordship.
Then you turn to clause number 2.
Yes, Your Lordship.
You read the clause number 2.
Without prejudice to the provisions contained in the sub-rule 3, where a government servant dies, A, after completion of 1 year
1 year
of
of
continuous service.
Then you come below number 3. You read 2(1) and then provide the proviso below 3. I'll read it for you. Where a government servant dies after completion of 1 year of continuous service, then or number 2 comes, then or number 3 comes. Then you read the family of the deceased shall be entitled to family pension. Now, who is the family? You see this rule 14, that it is the wife. So the rule says she's entitled. The AG's letter will have to be struck down. But for an interpretation of this nature, we require some authorities. You are not placing any authorities. There are judgments. There are judgments. So, what to do?
Next week?
Next week. Matter be listed next week for hearing. As paid for by the learned counsel. List accordingly.
Much obliged.
And
Bless
the
you, Lord.
government advocate appears for the state. Stress the key for accountant general.
My lord. Bless you, Lord.
For hearing item numbers 48 and 49.
This will take it up in the second half
Lodge.
because there's an administrative meeting
Lodge.
that to rise,
Lodge.
right?
In the cases, yeah. Something like.
Supplementary item 50 admission.
Yeah.
Oh, down after mistake. Okay. No, kasi ko. Oh, busy ba yung bahar house lang yung ko aso. Busy. 이자 뭐 appear 그래서 아직도 안 나오지 스코드.
Ki. Kuntu first of all, butter.
어디 그 아스비 나인. 오. 아스비 달라그라마 비마르기다 스포비제스. 디스 두다이 퍼스펙트 나 대아테는 거는. 아로 가는 게 뭐야? 아로 아인게. 아. One two na first. 212 or 212.
I don't want to go definitely because it's too late. Too late division. Too late division, whatever. So that's probably wrong. We don't know. Because you're little wrong. Time will be. Because 2 1 2 is, I can check in the other is better. Better, trouble kind of. It's written. 70.
36.30 yesterday.
Because it was yeah, because 36 and Mo ambil ini kan. Yang oke saya oh, saya masih step. Halo, Bapak. Efficient. Mention kurang lebih. Ibu lebih. Efficient kan terus kurang lebih. Kalau efficient nasi itu kurang lebih.
Tahun lagi mati juga. First update.
Oh, ada tuh itu fix aja.
Boleh. Jauh dominan. Karena ini fix.
Ya.
Before the break matinya.
Oke.
Itu continue dominan.
Oke.
So let them continue. Jadi tahun itu dia manusia di sini. So tahun itu first.
Tudo aquilo que não vem, tu ainda
Tudo atrás.
Karena discuss ke bawah aja.
Duit tak kisah situ. Ya, kita tuh proyek tadi yo.
Saya regulasi nanti mengingat pura. Nah,
dice fruto original,
ada masuk pun aku.
Aqui dice
Untuk regulation tu kopi panasnya di kali portfolio ini sudah pernah.
Oke. Alright.
Connect to trade with it. Immediately do the webinar. Fine. Admit could be VC like that.
Item 48, yes.
Lordship. Lordship matter pertains to non-release of funds after completing the project, Lordship. Lordship, may kindly allow me to refer to order dated 6/6/2014, Lord. 2024.
Six.
Yes, Lordship.
Yes.
May I read, Lordship? The petition and both the read petitions are the same, and the petitioners aggrieved by non-release of the remaining amounts due to the petitioner even after the petitioner have completed work. The respondents, however, denied that the petitioners have completed work. Be that as it may, it is seen from the enclosures to the affidavit so filed by the respondent that pursuant to the representation submitted by the petitioner, the respondent authorities have given a reply. In the said reply, it is seen that the said amounts have not been paid to the petitioner inasmuch as there has been no release of funds by the Ministry of Tourism, Government of India. This court, under such circumstances, had put a specific query upon Ms. So-and-so, Leonard Senior Government Advocate, Government of Nagaland, as to whether there is any document which would show that the petitioner was duly informed prior to entering into the contracts that the project contracts are being awarded on the basis of funding by the Government of India. The Leonard Government Advocate seeks for some accommodation, list a matter of on so-and-so, on which date the Leonard Senior Government Advocate shall produce the instructions. So pursuant to this, the Leonard Government Advocate has filed an affidavit, Lordship.
Where is your order of work order?
If the Lordship may kindly come to page 14, Lordship.
1/4.
1/4, Lordship.
Yes.
If the Lordship got it.
Yes.
This is dated 21st December 2013. It was issued by the Additional Director, Department of Tourism.
Is there agreement?
No such agreement was executed, Lordship.
No agreement. Where is the advertisement or tender or whatever it is it available?
No, Lordship, it's not available.
How did you apply? How did you come to know that the government is intending to execute a tender? Must be pursuant to some,
Yes, Lordship, but at the time of filing the read petition, I couldn't get such documents, Lordship. However, it's not disputed that the petitioner was awarded a contract.
we just want to find out.
Yes,
whether
Lordship,
in the advertisement, was there any indication that it is a question of funding from two sources?
The government has admitted the fact that it was not informed to the petitioner when the work order was issued, Lordship.
No, may not be in the work order, but yes, government, how did you advertise this tender?
Yes, Your Lordship, we have admitted that prior to issuance of the tender, that was not informed, that it was a central scheme to the petitioner. But however, Your Lordship, the petitioner is aware. If Your Lordship will see in para 10 and 11 of the repetition, the petitioner is very well aware that it's a centrally sponsored scheme.
In the tender notice floated,
Lordship,
there was no indication.
no indication, Your Lordship. But Your Lordship, it's a 100% centrally funded scheme.
Then who's for the central government?
Your Lordship, here central government is not implemented, so it will be a necessary party, Your Lordship.
You have not received funds.
We have received only 20% of the total fund, Your Lordship.
If the Lordship may allow me to.
As the first installment, Your Lordship.
Yes.
If I may allowed to refer to page 25, Lordship, the decision of the central government, Lordship, the Central Ministry, Department of Tourism, Lordship, they have taken a decision to delink, Lordship, the project. And it was specifically informed to the state government to manage from their resources, Lordship. The communication is there, page 25. It was in the year 2017,
Yes, it was
Lordship.
delinked, Your Lordship, in the year 2017.
Page 25, Lordship. It's a short communication, if I may allow to read the content of the letter, Lordship.
Yes.
This is dated 13 February 2017. This is addressed to the Secretary Tourism Government of Nagaland. Dear Sir, as you are aware, the PIDDC, that is the scheme, has been delinked from the union support, and the scheme has to be implemented by the state governments from their resources. Accordingly, it is understood that you have been already undertaken, would be taking appropriate measures to complete the unfinished projects sanctioned under PIDDC scheme through the resources of the state government. As part of this internal exercise, Ministry of Tourism would like to request you to provide the utilization certificates in respect of the funds already released for such unfinished projects sanctioned under the PIDDC scheme, along with the details of physical progress made thereto, achieved through utilization of funds released by MOT. Unutilized funds, if any, may also please be made available to MOT in case it is not possible to provide corresponding utilization certificates. Due priority may please be accorded to the above, and necessary details may kindly be provided at the earliest. Subsequent to Lordship, if your Lordship may kindly turn to the next page, page 26. There's also another communication in the year 2018, Lordship. May I read it, Lordship? Page 26. As you are aware, the PIDDC scheme of Ministry of Tourism has been delinked from the union support. The state plan with effect from financial year 2015 to 16, this is important, Lordship. After the higher devolution of 42% of union taxes and duties to the states on the recommendations of the 14th Finance Commission. Accordingly, no budget allocation with effect from the financial year 2015 to 16 for the scheme under the state plan was made available to Ministry of Tourism. However, Ministry of Tourism and donor have been persuading Ministry of Finance to allocate funds for the said projects which were in the advanced stage of completion. In order to facilitate this exercise, it is imperative to know that the current status of all the PIDDC projects which are in advanced stage of completion, that is more than 50% physical progress achieved on ground. I would appreciate if you kindly see the ministry, the requisite information in the enclosed form so that the ministry can again take up the matter with Ministry of Finance.
Since which year the amounts were due?
2013, Lordship. 2013. I have completed the project in the year 2013.
You completed in 13.
Lordship, the work order was issued in the year 13.
When did you, since which
14, 14, Lordship. I completed in the year 14, Lordship. And it was linked from the financial year 15 to 16.
And you come before this court for the first time in 23.
Lordship.
Why?
I have also made representation before I approached this honorable court, Lordship.
Representations are not sufficient. You should have filed a money suit.
Lordship may also kindly appreciate, there's a document that shows that part payments were also made by the department, Lordship, page 19.
What is this order that you have enclosed at page 27?
37, this is pertaining to a similar case where this honorable court
What direction was issued?
to pay the undisputed bill as well as even the interest.
What happened after that? Amount released.
Yes, Lordship, amount released. Even the interest of 6% was also paid to the petitioner in this case, Lordship. In excess of amount of 226, Lordship.
You are praying for a similar order.
Lordship. Because the liability is undisputed. And if your Lordship may kindly come to page 19, Lordship, it says that 11 lakhs.
What is your prayer now before the court? Tell me.
A direction to the state government to release the pending amount, Lordship, the undisputed pending amount, Lordship.
Is there a dispute that he executed the work? Madam,
Your Lordship,
is there a dispute that he executed the work? Is there any dispute with regard to
Your
that?
Lordship, till now, no official record, Your Lordship.
Official record?
Yes,
What is the meaning?
for, to.
Work completion.
Oh, yes, yes, yes.
Lordship, they cleared this
Your
honorable
Lordship,
courts.
the picture, Your Lordship, a reply to the petitioner's representation at page 16, Your Lordship. The position of the state, Your Lordship, is clearly protected
Page
here
16 on.
of my affidavit in opposition. In WPC 210.
But why were you pursuing the release of payment if there is no work conclusion certificate?
If your Lordship may kindly come to page 18, it has been verified by a competent authority, Lordship. Page 18. In fact, this verification process was undertaken only in the year 2021, Lordship.
Page 18 of the affidavit in opposition.
18 of my writ petition, Lordship. Sorry for the trouble, Lordship.
Trouble. 18,
Page 18 of the writ petition, Lordship.
yes. Verification report.
Verification. May I read it, Lordship? It is dated 19 April 2021. Consequent upon the request met by the concerned beneficiary, the undersigned had conducted spot verification of the following structure activities undertaken under integrated tourist destination at so-and-so in Nagaland. These are the 4 items, Lordship. At the bottom, it is to certify that.
Yes.
It is to certify that the above mentioned activities has been completed satisfactory. Therefore, the concerned authority may kindly conduct technical verification and release the pending
This is
payments at the
just a
earliest
verification
possible.
They
report.
have-
There is
they
no
have-
completion certificate.
That
It's
they-
just a verification report, Your
That
Lordship.
they have denied by, in their affidavit.
Lordship.
They have denied this.
Sure.
You have not received any payments.
11 lakhs, Lordship, out of 29, Lordship. I've also enclosed the amount which I've received, Lordship. I
Now,
got,
where is the report that they did not complete the work? Government, where is the report?
Your Lordship.
What is this document at page 13 of your affidavit?
Yes, Your Lordship, page 13. These are some of the reports of the verification, Your Lordship. Conduct by the government officials, by the department officials, Your Lordship. No, yes,
What is the reply
Yeah.
to this? Page number 13 of the affidavit.
Yeah, I have filed an affidavit in reply, Lordship.
No, but you have filed, what have you stated there?
The contentions are like paragraph 5, Lordship. The verification was conducted only in the year 2024 after filing this instant read petition, Lordship. I have completed in the year 2014, Lordship. After 10 years, they are conducting the
No, but
verification.
there's a disputed question. They say you have not completed. Look at their, what have you stated in your, look at the reply which you have given to the para 7 of their affidavit.
Lordship,
In your reply, para 5,
Lordship.
you're merely denying it. You did not receive site plan for contractual works, but
Yes.
orally intimated. Then there's a disputed question of fact.
Lordship, if a direction may be issued for all fairness, Lordship, to come up with the percentage of work that has been completed,
Who will
Lordship.
measure it? Who will measure it?
An independent committee, Lordship.
Give us the
Engineers,
name.
Lordship.
Give us the name. Give us the name of the committee who will measure it. Who is to be, this is the, under what department? Tourism.
Tourism Department. They have also their
Who's the-
technical branch in the tourism department headed by the executive engineer, Lordship.
Measure it and compare it with regard to what?
With regard to the work that has been executed, Lordship.
You execute a work as per the requirement.
Yes, Lordship.
You can't go to the site and execute any work and say, I've done work, pay my money. There will be a requirement by the
Lordship.
employer to
Yes,
say that
Lordship.
you are required to construct X, Y,
Yes,
Z
Lordship.
on
Yes, Lordship.
ABCD plot.
Lordship.
So whether this is as per the requirement or not is how it is being assessed by the departmental authorities on joint verification.
Lord.
And the extent of work done, measured and put in a measurement book.
Lordship.
So in your case, there is no plan. You say you have.
Yes,
estimated-
Lordship. I have disputed that, Lordship.
You have no plan.
A plan was not given to
Not
me in the
given to
first
you.
place.
So you
Yes.
constructed. Now, how will they go and measure your work, whether it has been done or not, as per plan? You have done some work. They have
Yes,
not
Lordship.
disputed.
Yes, Lordship. So the department can pay the whatever I have executed, Lordship. A joint spot
Have you
verification.
Have you heard this story of Rip Van Winkle? It appears to be the case. 2013 was your contract. You are available to there, and you wake up and one fine day come to court in 2023.
Lordship, the first verification was also conducted only in the year 2021, Lordship. I have been approaching the department, Lordship, all along, Lordship. And after
If you
filing
are-
this instant
if you are
read
not-
petition,
If you are not diligent,
Lordship,
nobody can help you. You have to be diligent. If you think you're entitled to this money, you
In
should
fact-
go and pursue it.
in fact, I have been running from pillar to post, Lordship.
Maybe, but you have come to the court late at such a stage that we are unable to now decide whether work has been done, and if so, whether it is up to the requirement.
Lordship. And the only stand taken by the
And
department
tell
is
me-
non-availability
tell
of fund,
Tell
Lordship.
me what is the limitation for filing a money suit?
Lordship.
What is the limitation?
Lordship, this honorable court has jurisdiction to pass this.
We have,
Like-
but should we? Why should we? We have the sufficient jurisdiction.
Lordship,
Why
at
should
least
we?
in instruction, Lordship, to verify as joint verification, Lordship. can be initiated by the executive engineer, Lordship.
I'm asking you that query, joint verification, yes, but once they verify, how will they measure up whether you have done the work as per the requirement or not? Because there was no plan.
It is also an arbitration position that they have released 11 lakhs rupees, Lordship.
They should be happy now, without measurement, without anything, they have released that amount.
Lordship, that was a part payment, Lordship. I've invested all my resources, Lordship.
All right, you set up a committee. Who measures the work here? Who measures? In the department, tourism?
The engineering wing, your lordship.
They have
Yes,
it?
tourism, yes, they have.
They have an engineer.
Yes, yes. But your lordship, Ministry of Tourism may also be implemented as a party, so that
Ministry of Tourism is not a party. Who is?
it's not a party
They
here.
have already taken the clear stand. They have taken a decision, Lordship, in the year 2017, Lordship.
No,
It has to be managed by the state government, Lordship.
No, tender was issued only on the approval of the ministry. If your lordship will see the lease of date, your lordship.
No, why is the Ministry of Tourism necessary?
Your lordship, it was because of their approval under the scheme, only this tender was invited, your lordship. So now if the scheme is delayed, then the liability cannot be, your lordship knows well that it cannot be shifted to the state now.
That is for you to complain, but you have
Your
not
lordship.
complained.
Your lordship, we have been pursuing the ministry, but until now, there is nothing forthcoming. So if your lordship may kindly, make
No, making the
Ministry of Tourism as a party.
Making the tourism a party will not sort out your issues.
Your lordship,
You had extracted work. What stopped you from stopping the work once the project was delinked? You are
lordship,
aware?
the department is anticipating, your lordship,
Then you keep on anticipating.
your lordship.
But that is
But-
your, if you want to pursue something with the ministry and they have not done it, it is for you to pursue it. This is
It's
not
true.
your petition, this is his petition.
Lordship,
He has a right to claim. You can't claim. between
lordship,
his
lordship,
petition.
that's true, your lordship, your lordship.
Heard learned counsels for the parties. This writ petition is directed against the non-release of the amount stated to be pending and payable to the petitioner. For execution of work under the integrated tourist destination at Angfang, Nagaland, in Nagaland. Stop. It is submitted that the petitioner was issued a work order dated 21st of December 2013. By the Assistant Director CSS, Directorate of Tourism, Nagaland, Kohima, Government of Nagaland. Stop. In terms of the said in terms of the said work order, the petitioner proceeded to execute the work. Stop. According to the petitioner, the work as required was executed and the scheme under which the petitioner was issued a work order was a scheme under the was a joint scheme under the Government of India as well as the Government of Nagaland. With their,
Your lordship, it's not, it's our tourism department is just an implementing agency. It's 100% centrally sponsored scheme.
right. What, do you agree with this submission? No.
Yes, Lordship.
Yes.
Provided.
Submits that it is the central government scheme. And the state was only the implementing agency. All fundings were required to be done by the central government scheme. You agree to the submissions?
Lordship.
Yes or no?
Yes, Lordship.
Yes, then I think she's right. You have to implement the
Yes.
union government. Otherwise, there's no effective orders can't be issued.
That's right.
Lordship, the only difficulty is the central ministry has already taken a decision to.
Maybe, but if it is, if its origins were in a central scheme, with central
Yes.
funding,
Lordship, yes, Lordship.
then you have to do that.
14 with
The grievance of the petitioner is that in spite of the work executed and verification submitted, the funds were not released to the extent payable. Stock an amount of rupees 11 lakhs
Yes, Lordship.
was released in the year
2013, Lordship.
2013.
Yes, Lordship.
And thereafter, the amounts were not released. Stop. Petitioner, upon pursuing the matter, came to be informed that the the central government, what is the department? Ministry of Tourism.
Yes, Your Lordship.
Ministry of Tourism had stopped the funding of the said project, and instead the government of Nagaland, government of Nagaland was now required to carry out all expenses connected to the said contract from their own sources. Stop. Better. The state government has filed their affidavit and has disputed the contentions of the petitioner that the work was executed. Stop. They have enclosed documents in their counter affidavit to suggest that the work as required to be done was not completed as per the
Plan.
joint verification made. Stop. Further, since the project was initially to be executed on central funding, the payments have not been received from the concerned central ministry, and therefore the amount payable to the petitioner could not be released.
Yes, yes.
So, considering the submissions of the councils that the contract that the project was initiated and the central government was required to arrange for the funding. This court is of the view that the government Ministry of Finance, sorry, what is the
Tourism.
Ministry of Tourism, Government of India, be arrayed as a party respondent. Stop. The petitioner will file amended post title before the registry, including Ministry of Tourism, Government of India, give the address wherever it is.
Director General, Government of India, Ministry of Tourism, Lordship.
Director General, Government of India, Ministry of Tourism, where is the address, if any?
Page 26, Lordship.
Address is at 26, New Delhi. All right. He is the Director General. Okay. Director General, who had authorized you to Ministry of Tourism, represented by whom? By the Secretary or Director General?
Lordship, I'll find out the appropriate address, Lordship.
Director General, Government of India, Ministry of Tourism. Stop. The amended post title be filed within a period of 1 week. The Director General to be arrayed as party respondent number 5. Stop. Mr. Santi Younger, line at CGC, appears for, you are appearing for central government? No.
Let us look at it now what the case, so the.
No, we'll record that you were present in court, therefore we had requested your appearance in the matter. It will expedite the matter.
Lordship, I'll furnish requisite copies, Lordship.
Done at CGC, being present in the court, the court has requested the learned CGC to enter appearance on behalf of the Union of India represented by the Ministry of Tourism. Extra copies be furnished within 1 week from today.
Lordship.
Mr. Leonard CGC, the liberty to complete his instructions and file necessary counter in the meantime. List after 4 weeks.
Lordship.
Thank you.
Much obliged.
Yes.
From the supplementary cost list for admission item number 50.
Yes. What is this?
Your Honor,
Yes.
in this matter, I'm yet to receive the main copy of the writ petition, Your Honor.
Dr.
however-
Kuri, why alternative remedy? Is there available?
Lordship, the impugned order is grossly without jurisdiction. In this matter, briefly, if I may go submit before Lordship is aware of the taxation procedure. The tax is levied on the works contract, and it is a single point of taxation. And in the impugned order, what has the assessing authority has done is he has levied tax upon me, being one of the partners of joint venture where I have executed the works contract. If a lordship may come to the impugned order, which is at annexure 1, starting at page 29, and the relevant portion starts at page 54. The discussions and findings.
Yes.
Lordship is, I'm not submitting any judgments as of now on the alternate remedy where it is not a bar. Supreme Court has held that when it is grossly without jurisdiction, the writ petition is maintainable. Lordship, I'll directly come to clause B.
Yes.
During the period of taxation, the said noticee was engaged in the construction of four-lane Dimapur-Kohima road in addition to forming a joint venture in association with Ramki Infrastructures Limited and entered into the agreement in between them on 19 October 2015 to carry out the mentioned work contracted to Ramki ECI JV by the National Highways and Infrastructure Development Corporation Limited, Ministry of Road Transportation and Highways, Government of India. Here, the assessing authority has admitted that it was a joint venture and the work was allotted to the joint venture. I am one of the partners of the joint venture, and as per the joint venture, I am supposed to execute a part of the work, and Ramki is supposed to execute another part of the work. Ultimately, it's a one common works contract which has been executed and delivered as transfer property in goods to the National Highway Authorities, Lordship. Next, coming to clause C, all the service, what is the interpretation by the assessing authority, Lordship? All the service providing firms.
Why can't you not take up these issues before the appellate authority?
Lordship,
Same grounds can be urged.
but Lordship, when it's grossly without jurisdiction, I can appropriately come
Hey,
before
how do you say without jurisdiction?
Lordship.
Say it is without jurisdiction.
Without jurisdiction, there are 2 points which I'm challenging in this case, Lordship. First is the authority on the proposition of law which has been taken by the assessing authority, and the same works contract where tax has already been levied and paid by the joint venture. The assessing authority is saying that I, being a separate registered dealer, I also am liable to pay the tax again on the same works contract.
No, that's
Which is
right.
again
This is a question of law. This is not a question of jurisdiction. Jurisdiction is where the authority assessing officer is not authorized under the statute to enter into.
Yes, because as per the law laid down by the Honorable Supreme Court in Kenan Dankali and other cases, Lordship.
That is in the terms of the merit of the case to decide that whether the order of the assessing officer
Yes, that
is bad in law.
Lordship, that can be looked after by the High Court itself while exercising jurisdiction under 226.
Why should we when there is an appellate forum?
But
it's the whole purpose of an appellate forum, statutory forum.
True.
Then
there is a statute forum.
You are evading going to the appellate forum because you don't want to pay the statutory default.
No. We have already paid the taxes, Lordship. It's not that we are not paying the taxes. Tax is already paid. Additionally, it has been levied upon us.
These matters before the appellate authority.
My point of challenge are on 2 points. First is on this interpretation of law, where the Honorable Supreme Court has held that it cannot be taxed twice. It's a common works contract,
You
and
can
it can be
take
divided.
all these issues, all these grounds before the appellate tribunal, appellate
It
authority.
is the same officer who has passed the order, and the officer before him whom appeal will be filed is again the same officer, same rank, Lordship.
No, no, same rank is different,
How-
same officer is different. It may be
In
the
my
same rank. It doesn't make it the same officer.
and the second point of and the second point of contention, Lordship, here is the additional commissioner who has passed the impugned order. He is not authorized under the Act to pass this order under the provision of Section 73 of the Central Goods and Services Act. It is the superintendent of the central taxes who is authorized, but not the additional commissioner. We have taken that point in the SOCO's reply also, which was also not considered by the officer, Lordship. If I may, for timing, if I may take Lordship to the
Why are you,
judgment.
why are you burdening the High Court? For what purpose? It's not a case that there's no efficacious alternative remedy. Yes, if you have a point, you can urge it before the appellate authority.
No, that is the point, Lordship, because the approaching the appellate authority will not be an efficacious remedy. Because
Mr.
I can, Lordship,
Mr. Counsel, please hear the court. Is it a case that the appellate authority would be incompetent to decide the reliefs you are seeking for?
may not be.
Then what
But
is the purpose of having statutory forums if you are not required to approach it? Yes, alternative remedy is not an express bar.
Lordship.
Courts can still exercise their jurisdiction, but you have to satisfy. Is it a
But
mandatory order?
yes, for that, Lordship, we have to go into the assessment order and see that how the assessing authority has taken a wrong interpretation, violating the law laid down by the Supreme Court.
Wrong interpretation is something you can urge before the statutory forum. You know the cardinal principles where the court will exercise jurisdiction.
True, Lordship. That has been continuously laid down by the Supreme Court. It's either without in violation of principles of natural justice, or Lordship is uh, virus of the legislation is challenged, or the order of proceedings are wholly without jurisdiction.
Right.
My point is the order is wholly without jurisdiction, Lordship.
Where is the
If I'm
GST? Give us the GST.
on similar lines, Lordship, Honorable Supreme Court has recently held where it has been summarized all the previous judgments of the Supreme Court in regard to alternate remedy, Lordship, and mandatory of 226. And it has been held that even for ascertaining whether it is maintainable, how it is without jurisdiction, Lordship.
You're saying without jurisdiction with reference to which section?
Section 73 under which the impugned order has been passed.
Why is it without jurisdiction?
Section 70 speaks of determination of tax not paid or short paid or inversely refunded or input tax credit wrongly availed or utilized for any reasons other than fraud or any willful misstatement or suppression of facts. The starting line, Lordship, where it appears to the proper officer. The proper officer, as per my contention, is not the additional commissioner. It is the superintendent of the central taxes, Lordship.
From which provision are you saying that?
Lordship, for that definition, I have come with the notification issued by the central government where the government has authorized officers for different empowerment under different sections, Lordship. My learned friend will assist, Lordship, by submitting that notification, the circular by the central government. The first circular is circular number 3/3/2017 GST. Has a Lordship got that circular?
Yes.
Yes. The circular 3/3/2017, the subject is proper officer relating to provisions other than registration and position under the Central Goods and Services Act 2017 in exercise of powers conferred under Clause 91 of Section 2 of the Central Goods and Services Act, read with Section 20 of the Integrated Goods and Services Tax Act, and subject to subsection 2 of Section 5 of the Central Goods and Services Act, the board hereby assigns the officers mentioned in column 2 of the table below the functions as the proper officers in relation to the various sections of the Central Goods and Services Tax Act 2017 or the rules made thereunder given in corresponding entry at column 3. If your honor comes to serial number 2, additional and joint commissioner of central taxes, the functions which have been allotted are under section 67, 71, proviso of 81, section 129, rule 139 and rule 140. If your lordship come to serial number 4, superintendent of central taxes, column 3, point number 8, subsection 1, 2, 3, 5, 6, 7, 9, and 10 of section 73. So it is the superintendent of central taxes who is the proper officer.
When was your assessment completed?
Assessment was completed in the year 2023, August 2023, Lordship.
Okay. Then what happens to the second notification?
Second notification, again, what they have done is, here they have changed the power, where power to under section 73 was given to power under section 74 was additionally given to the superintendent of central taxes. If your lordship come to the first paragraph, the board-wide circular number 1/1 2017 assigned proper officers for provisions relating to registration and composition of levy under the Goods and Services Act and the rules made thereunder. Further, wide circular number 3/3 2017 dated 5th July 2017, the proper officers for the provisions other than registration composition under GST Act were assigned. In the later circular, the Deputy or Assistant Commissioner of Taxes was assigned as the proper officer under subsections 1, 2, 3, 5, 6, 7, 9, and 10 of section 74, while the Superintendent of Central Taxes was assigned as the proper officer under subsections 1, 2, 3, 5, 6, 7, 9, and 10 of section 73. It has now been decided by the board that the Superintendent of Central Taxes has also been empowered to issue so-called notice.
You come to clause 5. Clause 5 table.
Clause 5. Okay, this circular, Your Honor.
Yeah, the circular date, circular number 31.
31, clause 5. Whereas for optimal distribution,
You come to the table. You come to the table.
yes,
There you find serial number 3 is the additional or joint.
additional commissioner and joint commissioner, but without assigning the powers. How can the quantum be defined, Lordship?
What is the meaning of without assigning? This is the circular assigning power.
Circular, but the power has not been assigned to the additional commissioner.
No, it's a continuation of the earlier circular.
Earlier circular,
Above monetary limit of 2 crores of tax demanded.
yes, that is okay. But the thing is, the exercise of power under section 73, who is the proper officer? The proper officer is the Superintendent of Central Taxes, as your lordship has seen in circular 3/3 of 2017.
You are relying on circular 3, but circular 31 is an extension of that.
Here, but that power under section 73 has not been removed. It has only added the Superintendent of Central Taxes of section 74.
It says for passing orders under 73 and 74. Column number 5. An additional commissioner is the proper officer for any amounts above 2 crores without any limit. So therefore, you are relegated to the tribunal.
That is the thing, Lordship, because unless he has been assigned the powers to exercise, just referring to quantum will not serve the purpose. And
No,
again, this similar line also,
This particular circular number 31 is
Lordship,
by the same CBEC.
same authority, Lordship, the board,
This is an extension of the earlier circular.
earlier circular.
So
But
it does not mean that the earlier circular, the earlier circular has to be specifically overruled. Both will have to be given a proper.
not question of overruling, but like in the second circular,
Kindly say clause 4. All officers up to the rank of so and so are assigned as proper officer. Under subsection 1, 2, 3, 5, 6, 7, 9, 10 of 73, 74.
right? It says in other words, but unless you have specifically assigned,
How specific do you want it to be? How
because
specific do you want it to be?
if your honor, if your lordship reads the opening paragraphs under the exercise of powers under the Central Sales Tax Act, they have assigned the proper officer for a particular section. In the earlier one, for section 73, it was the Supreme of Central Sales Tax.
By
In the
the
second
subsequent-
one, Supreme of Central Sales Tax has been assigned additional power under section 74.
By the
But it has not
circular, it has been clarified that 73, 74 proper officers up to the rank of joint commissioner. And the table shows which will be the proper officer. The earlier circular was exclusively for without any pecuniary limit. Subsequent circular has set the pecuniary limit. That is how the additional commissioner became your.
pecuniary limits have been set, but without assigning the powers.
Have you put these notifications to challenge?
No,
Saying that
because,
these are not authorized notifications?
no, challenge to that is not required because in my humble submission and interpretation, the additional commission doesn't have the power. And similar facts under the Customs Tax Lordship, similar powers were assigned to the officers where Honorable Supreme Court, in the case of Canon India Private Limited, has held that who will be the proper officer. Similar interpretations has been done by the Honorable Supreme Court. If a Lordship may kindly come to the judgment I have provided, Lordship, 2021-18 SCC 563.
Where is the judgment? What about the government? What do you say?
Your Honor, I have not received the copy of the writ petition from the department. I have just received the affidavit in opposition and the copy of the affidavit in reply. So I'm not in a position to, so I have no instructions regarding this, Your Honor. However, Your Honor, in my affidavit in opposition, there is no statement regarding specifically about this one. So I don't know whether the petitioner has taken this stand before this court.
Not even gone through the copy of the petition. Mr. Todi, you request your colleague to serve a copy of the petition.
Will serve it, Lordship.
No,
As he has been recently appointed, Lordship, I was not aware.
You
Earlier,
serve
he-
if possible. List
will
next
serve a copy.
After 2
After
weeks.
2 weeks.
Yes, sir.
At the request of learned standing council,
Yes.
CGST,
Oh, no, yours. Yes, standing counsel, senior standing counsel.
for
The CBIC.
CBI,
Yes, sir.
Central Board of
Indirect taxes and customs.
Direct Taxes and Customs. All right, Mr. Todi appears for the petitioner. List after 2 weeks.
Your Worship, my name will be reflected in the cost list and
Your name,
Z Kulno.
Z. Kulno, learned standing council, CBIC. Be reflected in the post list by the registry. Yes.
Much obliged. Your Honor.
Lordship, there's an interim. I'd kindly to continue, Lordship.
Interim order passed earlier, will continue.
Lordship.
Yes.
Highly obliged.
Obliged.
Much obliged.
For hearing, item numbers 36 and 37.
What is this termination?
Yes, Lordship.
Termination. From the sub rifle. Not following this rule.
Lordship, if my Lordship may, it's a part matter, Lordship. Lordship, I've already heard, so may I take your kind attention to the writ petition, the judgment of court in the writ petition,
Judgment
the judgment is.
in
Page
the, in the
21.
writ petition.
Yes, in the writ petition, yes.
Okay. Page number.
Page 21, Lordship, is a judgment, and the relevant portion is, the relevant portion is page 25, Lordship.
Yes.
It said, may I read, Lordship, page 25, para 10.
Yes.
Para 10, Lordship.
Yes.
That in view of the matter, the impugned order dated 15/5/2000 is set aside and quashed, and the respondent are directed to reinstate the petitioner back into service, wherein within a period of 3 months from the date of receipt of the certified copy of the order of this court. The next is very relevant, Lordship. It is, however, left to the wisdom of the respondent to issue appropriate order if so advised. Lordship, this is very important, Lordship. It is, however, left to the wisdom of the respondents to issue appropriate order if so advised. That if my Lordship may come to my my affidavit in opposition, Lordship.
Yes.
My affidavit in opposition, page 25.
Just refresh my memory, what he was dismissed from service.
He was dismissed from service under the Army Act. Army Act. He is an Assam Rifle. He is Assam Rifle, Army Act. And if my Lordship may kindly.
Was he dismissed, discharged? Or
Discharge.
discharged.
So if my Lordship may kindly,
Discharge means no pension,
no. Yes.
no pension.
If my Lordship may kindly come to page 25 of my affidavit.
25.
Yes.
Yes.
So as per the direction of this order, because we have been given the liberty, Lordship, by this court, page 25 and 26 also. I may be allowed to read, Lordship. I set aside, I'll just go to this. I set aside the summary trial proceeding in respect of so and so held on 29 June 2029 on the ground of lack of jurisdiction as the proceedings were conducted under Army Act, Lordship. Army Act 1950, section without sufficient cause overstaying leave granted to him.
Yes.
And the next page also similar.
So
Same order.
Set aside.
Set aside. So under the Army Act, it was set aside.
Then what was left?
Then what happened if my Lordship can come back again to page 5 of my affidavit?
Yes.
Page 5. Lordship, it's Roman, I'll read again, Roman 5 and 6. The petitioner was reinstated in service in compliance with judgment order so and so, was in writ petition number so and so. After reestimate, he could not be instantly discharged against because his 2 red ink entry incurred under the Army Act 1950 after enactment of the Assam Rifle Act 2006 were set aside, and only 3 red ink entries remain in his service dossier. Then 6. It's very important, Lordship. After reinstatement in service, the petitioner knew that if he incurred 1 more red ink entry, he will be discharged from service as an irrecoverable offender. However, he made scant regard to the disputes, to the disciplines, and committed offense again on 27/4/2017 by absenting himself without leave, remaining absence for 4 days. And the act of intoxication on 30.
Before you put in a red ink, is it necessary to, or after you put it, is it necessary to bring it to his notice?
Lordship, he was given a notice, he has admitted to the offense.
Reading is for certain misdemeanors.
Yes, Lordship.
Intoxication or fighting or this, that.
Yes, absenting without
So-
absence. Absolutely.
Reading, once you put the reading, how does he know that he's put the reading?
No, Lordship, he has been given the notice. After that, he has been given the notice. He has been given the notice and he has replied to the notice also. Lordship, it is a question of intoxication, it's a question of absenting without leave, it's a question of
What is the?
overstay,
Yes.
overstay of leave.
What is the provision with regard to reading? What happens when you? What happens? Right. 108.
Okay, right. 108 says, Lordship, of the Assembly Regulation Act says that if the delinquent incurred three red
Reading.
ink, Your Lordship.
Four or more. 108 is four.
108A. After an individual has earned three red ink entries,
He shall be.
he shall be warned in writing that his service will be liable to be terminated by competent authority if he earns one more in entries, Lordship. He has warned that. He has been already warned, he has been show cost. And even after that,
What is his, how many years of service?
19, he has not completed 20 years, 19 years something, Lordship.
So why clause C was not made applicable?
Let's see.
Because what has happened in this matter is this individual earlier. So once there is an offense of absent without leave or overstaying your leave, so the period for which you are absent is not counted towards your qualifying service. So there are two terms. One is qualifying service and one is non-qualifying service.
Where have you explained that? In the order,
Lordship.
where is it explained?
Lordship,
Under-
this is in separate pension regulation where you become entitled after 20 years of service, which provides that what is qualifying service and non-qualifying service.
This interpretation that you're providing, you are deriving it from which particular statute, rule, regulation?
If my Lordship may kindly allow me, page 71 of my affidavit is the judgment of the Meghalaya Court.
No, we'll go to judgments. We are trying
Yes.
to understand. the
Yes, that's why I'll explain, Lordship. If my Lordship may come to page 71 of my affidavit.
71 of your affidavit.
The relevant portion, that is page 71.
This is.
Judgment of the Meghalaya Court, Lordship.
Rupesh. You're referring to Rupesh? No.
No, Lordship. Observation of the, this is the Impal Court, Lordship. I'm sorry.
Imphal Court,
Yes, Lordship.
71.
Yes, the relevant portion, just the relevant
Yes.
portion, Lordship.
Yes.
May I read, Lordship? Para 29, Lordship, page 71, para 29. The petitioner being a member of the armed force, high level of discipline is required.
No, this is your conclusion. We'll come
Yes,
to
this is the
that.
conclusion. Same case, Lordship, same case, Lordship. He was,
All right, let me give you your satisfaction. Where is that page number? 70?
71, Lordship.
71.
Because the petitioner,
You read paragraph 21, what does it say? He has failed to maintain discipline and has done grave misconduct.
yes, Lordship.
This is not the ground on which you have.
This is also
No,
great, because he was intoxicated. He has,
Your regulation says it is 4 red marks.
my lord.
Each red mark, one may be because of drunken fight, one may be because of overstay, one may be because of something else.
Yes, my lord.
But total 4.
Yes, my lord.
Once he gets 4,
Yes,
then you put him to notice, said you are no longer required, get out.
my lord, my lord.
But there is a provision clause C where it says if he is put in 18 years or 19 years or whatever, and his pensionable service is about 1
20.
year or 6 months or whatever, then you should try and allow him to continue. Unless there are very strong and compelling reasons.
Lordship, we have given a show cause notice to him to improve himself. In spite of the show cause notice, he has, in spite of the show cause notice, in spite of the show cause notice, Lordship, please, my lordship.
You are not getting the query of the court. These submissions that you are making will have to be supported by the records.
My lord.
The records must have a reference to the relevant statutes or the
Lordship,
regulations.
Lordship, may clearly understand that he was given a red impact under the Army Act. Because of that has been expunged. Even after that, he is continually violating all the Assam Rifle rules.
So that is okay, but under your provisions of reading, what is that provision? 108.
108, Lordship, yes.
Your provision for reading is referred to in 108 or some other provision? It is in 108 only.
Well, 108 of the Assam Rifle.
108 itself has a provision called clause C. Clause C says that if one was put in 18 years, he may be allowed to complete. If your pensionable, the mandatory service period is 20 years, then which means even if he's 18 years, he should be allowed to continue for 2 years, even with all the reading. In your case, you said he is 19 years
So
plus
let's
something.
explain, there are riders in this. Not as
Show us the
simple.
riders,
Your
show us
lordship.
the riders.
The riders is, your lordship, the peculiar facts of this case. First of all, this individual, when he got the reading entries, therefore absent without leave, it totaled to good about a period of 2 years. Your lordship will see those 2 entries which have been set aside. One was for a absent without leave for 226 days, and then these periods are adding up. When you add them up, he does not even reach 19.
So from which provision are you saying that?
Your lordship just have page 5 of our counter affidavit. I'll just demonstrate to your lordship that how the different offenses, your lordship, these absence period.
You cannot have this unless
Please, your lordship.
this has a source in some rules or regulations.
Please, your
Show
lordship.
us that. These are interpretation of your rules. We want to see what the rule says, parent rule or the regulations.
Lordship, my only prayer is that the petitioner
Lordship,
is
just have
one.
Regulation 112, your lordships. It's on the.
My only prayer is, Lordship, the petitioner is on the armed forces. Utmost discipline is to be required.
But notwithstanding that, your regulation 108.
Yes, Lordship. Still,
Anyone who gets a red mark means that he is guilty of some indiscipline.
yes, Lordship.
So 1 red mark, 1 indiscipline instance, 2, 3, 4. So even if somebody has 4 instances of indiscipline, even then, if he has completed 18 years, allow him to continue ordinarily, unless you have reasons to do so.
Lordship.
Now your officers are saying that
Lordship,
the moment he completes, the moment he gets 1 reading or overstaying, etc., then the number of days which are to be counted gets deleted.
Lordship,
That's what you're saying.
And Lordship, the more than red ink is more than 4. And he has never challenged that rating entry.
He
He has
does not
never
want to.
challenged.
He does not want to. He does not want to get back to your service. This writ petition is not for that. He is not challenging the discharge to get back into service. He is challenging it to complete that qualifying years to get his pension.
No, he is also challenging
Lordship,
that.
then he'll not be able to complete the qualifying service itself if he doesn't get reinstated. And your Lordship, the peculiarity in this.
The reinstatement is for that purpose, to complete that service.
Your Lordship, what has happened in this case in 2010 when he was discharged, he was out of service from 2010 till 2015. In 2015, he got reinstated, and there is a separate writ petition which he is filed for that period that he should be taken as in service during that time, which is also pending before your Lordship, and he should be get back wages for that period. And while projecting it to your Lordship, that's 19 years, some months, he is including that as well. Plus those years whenever he was these 4 days, 22, 26 days, when they total up, that period also is counted. And if
Is
you
it
got
correct, Mr. Longcha?
No.
Why have you not connected both the writ petitions? Assuming your
It is,
earlier writ petition.
includes in this petition also,
No,
earlier petition.
earlier writ petition, if it is dismissed, then that particular period is gone.
And Lordship,
It is allowed.
I'm sorry.
It's allowed.
Yes.
I'm sorry
So
for
that is-
this thing.
Come.
There is again a contempt petition in the same case also. Filed by,
This matter.
yes, in this
So-
matter.
Earlier, this honorable, this court has said.
It's
that
all related,
he-
Lordship, it's all
he-
related to that.
His discharge is question set aside.
So
what
when there's
happens is
a, when
that-
there's a writ petition pending, two writ petition pending, why contempt
It is
petition?
allowed.
No. Then what happened, instead of paying him his salary, it was not paid. So the petitioner again approves this honorable. Directed to pay for to treat the same period as.
Have you stated in your affidavit the history of the case?
yes, page 5.
Page 5.
So my prayer is, Lordship, let all this matter be listed together. Because it,
But that you should have mentioned on the day when we started hearing the matter, after hearing the petition. For one.
I'm sorry for that, Lordship. I'm sorry for that.
You wasted your
Yes,
time.
yes, I'm sorry for that. I'm very sorry, Lordship.
You should have pointed out.
Under this petition can be decided independently, uphold that earlier issue, which is the other two petitioner for in connection with the earlier this honorable court order. There was a writ petition, there was a writ appeal. In spite of that, you have not.
No, you are
taken-
not giving the
Yes.
facts clearly. You prepare a chart and tell us what writ petition was filed and what order was passed.
My lord,
Do it by today.
no, I have already
Where is
stated
it?
in my writ petition,
Where is it?
yes. It starts.
After hearing the matter, you can't say
Yes.
that these matters are pending and therefore
No,
we wasted
You cannot-
one whole day.
I'm very sorry. I'm very sorry for that because of the contempt petition. I'm very sorry.
my
I-
page 4, it starts. Writ petition 3, K of 2015,
Yes, what happened there?
then judgment order
It
on
set aside.
29/7/2015. It's annexed in this petition.
Yes,
Then, in spite of that, we have taken that particular period as Dayas none. So the petitioner have to approach this honorable court.
yes.
And by annexure 4, the writ petition was allowed. Then the respondent they filed writ appeal number 3, 2018.
Hmm.
And this honorable court by order dated 29/5/2019, annexure 5. Appeal number 2 is directed to consider payment of back wages to the respondent if any for the period from 15/5/2010 to 19/9/2015 by keeping in view the propositions which have been reproduced in the foregoing paragraph and also considering whether the respondent was employed in earning elsewhere during his period of discharge.
Where is the contempt petition now? Where have you stated about the contempt petition?
It is not stated, Lordship, in a petition.
Then
My lord, contempt was filed after filing of this writ petition.
for what?
Because for that particular point of time, they just give the ROP 7CBC revision without paying him the salary. Error of the increase in the revision, not the salary, as directed by this appellate court.
Lordship is that, my prayer is that these two petition as well as the contempt petition be taken up together because
What?
No,
What petition?
it is no
He
connection
says it is-
whatsoever.
it is-
there is no connection in that, but arriving of the same cause of action.
What petition?
The
Which-
contempt petition filed by the,
Subsequent in relation to the earlier proceeding, it has no connection with the present proceeding.
Contempt you filed against non-compliance of which order?
The read single bench as well as the appellate division bench. Because
That-
it is clear.
That issue with regard to non-dias.
Yes,
nonetheless, yes, Lordship.
Your Lordship, if I'm explaining that,
Yes.
in that matter, what the Lordship directed us was to pass a speaking order, consider what are the peculiarities of this and pass a speaking order, that in those 5 years, what back wages he's entitled to, what all he's entitled to, that was the direction. So speaking order was passed. Now, what has been passed in that speaking order, that he's challenged to the contempt petition, which is separately going on. Now, your Lordship's query with respect to the qualifying service, which is in the Charlie provision 108, he does not qualify for that. His primary contention in the present petition is that those two reading entries are under Army Act. So they should not be counted, and therefore he did not get 4 reading entries. So this discharge order was not correct, and this show cause notice was not correct. This point of what your Lordship has pointed out, that even if he calculates all those period where he was absent without leave, in any case, even if he's punished, will not be counted towards qualifying service. It is never that I am absent for 2 years, then I come back, I'm punished, and then that period is counted for my pension. That even if those 5 years, your Lordship tomorrow decides and gives him those 5 years that he was in service, say your Lordship is to give a judgment to that effect, still he will not come up to the 20 years of service. And peculiarly for this,
Why would you not come up?
because your Lordship, he is not reached that much of service because of the other entries as well. Those absence and other things, he's not reached the period of 20 years.
That you point out from whatever sources you have, on what basis you are calculating that?
Your Lordship, with this, if I may just point out, when he was given the show cause notice initially, and your Lordship would see from the record, he gave him 2 blacking entries when he was reinstated. That was precisely for the purpose that he could complete that 20 years.
Is there a provision that because of his overstaying or leave without absence,
Yes.
his regular period of service gets deleted from that?
The absence period gets deleted. Your Lordship.
So from what provision are you stating that? We are asking you that repeatedly.
Your Lordship will for a moment have the regulations, Your Lordship, 112 pension regulations. 112 Bravo. Bravo, Your Lordship. This is for the pensions.
Yes.
My Lordship,
Yes.
I pray that this two cases as well as the contempt be heard together because there will be complicity of case.
We're trying to understand because
There will
we
be
have heard
complicity.
you- we have heard the matter for one day.
Yes,
If
Lordship.
these issues were there, you should have raised these issues.
Yes,
It's
that's right.
unfair to the court. This is unfair to the court.
In unfair, Lordship.
You also know today when you made a mention in the morning,
Yes,
you would have pointed out these issues.
yes, I'm very sorry for that, Lordship. I have not mentioned that
Being
facts.
naughty like that doesn't help.
I'm very sorry for that, Lordship. My apology. All this
Yeah.
matter.
This petition can be decided on its own because the admitted position is that Army Act is not applicable since they have already nullified that without jurisdiction. Show cause is page 40 of my writ petition. A, B, C, these are all Army Act. Once it is not applicable, the whole issue goes. Show cause itself is under Army Act, 1, A, B, C. Only D is Assam Rifle Act. In what their own affidavit says, page 42 may be seen, man.
That we have acknowledged, Lordship. We have acknowledged in my
What
theory.
it is acknowledged, the petition should be allowed, man. Because the show cause itself is A, B, C is under Army Act. Only D is Assam Rifle.
What is that order by which these were set aside? By the brigadier?
15,
Your own petition.
your petition.
No, your affidavit.
Yeah, page 25 of my affidavit, Lordship.
Yes.
25 and 26.
What is the effect of this?
So the red entry
Goes.
under the Assam Rifle, yes, under the
Under
Army
the
Act,
Army.
yes,
Close.
yes, close. But after that, Lordship, as I said,
There was one earlier.
there is again,
One earlier.
yes,
How many readings after setting aside, how many readings were
four,
there?
four. Four,
Here there was 4, 3 were set aside,
yes, Lordship.
1 remained.
Lordship, I have said it in para Roman, page 5, Roman 6. Page 5, Roman 6. My Lordship basically take reference to the date.
Actually, we thought we'll wind up the hearing today, but I don't know.
No, your show cause itself is APC is Army Act. In your admitting that not applicable.
Where are the records of the proceedings? Is it here? It's enclosed.
I did not get your Lordship, please.
There was a proceeding, disciplinary proceeding was initiated.
No.
isn't it? No.
No.
No, it's a summary procedure,
Summary
Lordship,
procedure.
summary procedure, so, records are all in my affidavit, Lordship.
All right. Very well. We are closing the hearing.
I was referring to.
You give your line of judgments, whatever you have. If you are willing to, you can give a short note, synopsis of the arguments and the judgments you are referring.
Okay.
It should not be more than 2 pages.
It's two pages, not big. At least 3 pages, Lordship.
You just give the citations of the case laws, 1 or 2 lines,
Okay, fine,
so that your
Once.
your submissions are streamlined.
okay.
Mr. MT, you are
Yeah.
you are entitled to give a written arguments if you want within 1 week from today,
Mal,
but should not be more than 2 pages. The
Mal-
facts, the
Mal-
issues, and whatever judgments you have.
yes.
All right? And we have this Assam Rifles regulation.
Yes, sure.
There's an act and a rule.
My lord, Assam Rifle regulation specifically in the preface, it is not in derogation of the act in rules.
It has to be because it is the regulation. It has
Regulation
subordinate to the act and the
instructions.
rules. All
Pre-
right. All right,
Preface is very clear.
we have heard learned counsels for the parties.
My lord.
Learned CGC is instructed by
Major.
Major Love, Your Lordship.
Major
Love Kumar, Your Lordship.
Love Kumar from Assam Rifles.
Yes, Your Lordship.
Okay,
If Your Lordship just permits me 1 minute, small point if I may convey, Your Lordship. Just one point, Your Lordship. Query Your Lordship had pointed out, he initially had 5 reading entry. 2 were set aside. What was the reason for that with Your Lordship? That Your Lordship in a matter which is annexed by the petitioner decided that the commandant does not have the power because the new Assam Rifle Acts made certain amendments. It was a DIG. On that ground it was set aside. Now these earlier Army Act reading entries, there is a SRO which made the Army Act applicable to all Assam Rifle personnel who were serving under the command and control of Army. This SRO is annexed data as
he is denied that, he is denied that his unit was,
it is, Your Lordship, till date, before 20th February 2009, when the Assam Rifle Act came into force, all personnel of Assam Rifles, they were under disciplinary control, Your Lordship, and just see the SRO. The provisions of 1941 Act were suspended for that period, Your Lordship, so they were
In
not
any-
charged under that.
in any case, these summary, these 3 readings were already set aside.
Not all, Your Lordship. Out of 5, 2 were set aside.
Who were set aside?
Because they were given after 20th February 2009 when the Assam Rifle Act came. So they should have been under Assam Rifle Act, not Army Act. Because the Assam Rifle Act took precedence and it in a way repealed that SR. That is why only these 2 were set aside and the earlier 3 were not set aside.
All right. Heard. Then it down to the parties. Reserve. Yes,
My lord, the other writ petition which is seem to be connected. This may not be taken up along with the present petition.
how many petitions are there? 2.
There are 2. What happened is this,
Still will condemn.
in the connected petition, my lord. After discharge, if deducted my
Just shortly, Lordship,
Yes.
if this petition is allowed, ultimately that other
yes.
petition will also be allowed.
Right, disconnect this
Yes.
280
yes,
to be listed. After 1 week, 2 weeks, whatever date you want,
my lord.
only this petition. With this is
But-
not required.
Yes, much.
What is the number that we heard? Writ petition number 212?
212.
212.
My lord.
All right. Okay. Yes, thank you.
Much obliged.